Law nerds, mount up. It's time for an extra ride. It's been a while since I have had a ride where it's not like Happy Friday Night Live or Happy Coffee. Here's who it's tonight. It's like Happy WTF Wednesday. There's a new episode of the Emily Show out. The video episode will be out shortly, but we have things to discuss this evening because y'all, I feel like it's 2020, 2021 all over again with some of these lawsuits, but we didn't finish the new complaint against Erica Girardi. We just didn't get all the way through it. There was so much in there. We're going to go through the second part of it. Well, it's not the full second part. We got through most of it. It's a very thorough complaint, but we're going to go through the second part of it. And then we are going to move into the 7M lawsuit. We will give all of the do not harass other creators. We don't talk about Bruno over here. We do not feed internet trolls. We will get into all of that. And then I'll be live again tomorrow because I'm moving Friday Night Live to Thursday because I am taking Friday through Monday off, sort of. I mean, we're still going to be doing podcast work, but I've got the live stream next week, or the live event in Nashville next week with Zach and Adam, and I just need a little minute to breathe. So we're bumping Friday Night Live. Tonight, I made the wise decision to bring 2 of Zach Peters' new white wines onto stream. The last time we did 2, it was spicy, but we're going to save can 2 till the end for questions. The mods are like, not 2, please not 2. This one says, cut down on my drinking or what? Or what? I love his can designs with the little diamond with the crown. We love it. And then this is for later. I'm going to need this because this is going to just bring it. I am going to need it. I'm not going out tonight. I'm disengaging, which is going to be me. Which is going to be me after this live stream. I'm like, I'm disengaging. I'm going to go get into my bubble bath and just disengage. So we've got Zach Peters collab white wines. If you guys don't follow Zach, hashtag no filter Zach. He's fantastic. Talks housewives. Zach is like an honorary Elle Woods. The man is so smart when it comes to the law, not a lawyer, but so intuitive when he reads things. And I love seeing how he interprets things. So this is his white wine. It's a collab with Eliquis, Eliqs, but I know he has them on his website and stuff. So we are going to do a can of this first. My favorite thing about these wines, first, they are like 13% alcohol by volume. So a little goes a long way, as I have learned. Like a little goes a long way. They are super low sugar. So with them being super, super like less than 1% sugar or one whatever of sugar, I don't want to misstate. I don't want to misstate things. Super low sugar, less than 1 thing of sugar. They don't give me a headache, which I really appreciate. Oh, the nails have gotten to the point where I need a thing. I need to phone a friend. Fred, come here and open your mom open some wine. No, we're going to use a tool because we need tools. So Paige said 13%, you have 2. Crazy? Yes, I am crazy. We might not get to the second one, but we're going to do it. We're going to do it. I saw Matt Bond's super chat. I will save most super chats till the end, but we're going to do this. Tomorrow night, I'm going to talk a little bit more about Ed Sheeran's Shape of You lawsuit, because I have been looking at a lot of the music stuff to do a podcast on music stuff, and then everything else popped off. And then I was like, oh, the Rob Kardashian Black China stuff will be super quick. There are three different lawsuits that have been consolidated into what's going to trial. There's literally nothing simple about it. It is so much stuff. It's like trying to dig into the Amber Heard, Johnny Depp stuff. There is so much stuff. So We will quickly cover Ed Sheeran winning his trial. He was at trial in the UK over Shape of You. There's a music channel here on YouTube that did a breakdown of the two different songs, not just by melody, but by like cadence and stuff. It was brilliant. I will look for that tomorrow and put it in tomorrow's show notes because it was really helpful for me to understand. I played the drums, but I am not by any extent a musician. I'm like, okay-ish. Okay-ish. So with that, it was really nice to hear someone who's very, very musically inclined break down the different melodies and the chord progressions and stuff like that on these lawsuits, because that's what matters, because the words can be the same, but the songs can sound very different. So with that, we should just start with Girardi. Do you do you see? We're just we're just gonna get into it because I know a lot of you are ready for the breakdown of the 7M lawsuit. Don't worry, we're gonna get there. But the Girardi tea is unfinished Girardi tea, so we have to finish drinking our tea before we're done. And again, I'll do all that as I swoop. Let's swoop. Replay crew. Heart hands with wine. There's timestamps down below. And for anyone that's like, girl, you talk for like 6 minutes, you get into there's timestamps. Also, yes, I talk a lot. Do you see the time on these videos? We talk, we chat. We're here for a chit chat together. We're going to have, as a lot of my friends call it, we're going to have some sweet tea time before we just jump right into it. It feels rude to just be like, here's a lawsuit. Let's talk about it. We gotta say hi. How you doing? Speaking of which, y'all, where are you coming in from? What are you drinking? I'm doing both. We're doing white wine and water. So with that, we should get going. We should just get into it. I haven't even rolled the intro yet. Lord, Emily, we are professionals here. Let me know where you're coming in from. Hey there. If we haven't met yet, I'm Emily D. Baker, the badass lawyer and everyone's favorite legal commentator. I'm the host of The Emily Show, and I break down the legal shit behind the news and pop culture stories we all want to talk about. I have been a licensed attorney for over 15 years, but this is not legal advice. I should warn you, I'm a big fan of the cursey words. This channel is where the law nerds unite to talk about facts, not fuckery. Y'all, I don't know if we're code red yet. We can only go code red when we get to code red. We can only get to code red when we get to code red. We can only get to code red when we get to code red. All right. With that, let's do a brief road so far of what has been going on with this latest filing. So the latest filing is there's so much in my brain right now that it just literally stopped. The latest filing is an exhibit to a filing in the Lion Air case that they Edelson PC told the court will be filed. So this it's happening. It's like the meme from The Office. It's like, it's happening. This will be filed if it wasn't filed today. I have not had a time to check. There's new Britney documents. I had called like today's been a busy day. So I have not had time to check. It might already be filed in California. But with that, the filing is the draft complaint. So it's like, hey, winter is coming. It is going to be filed. This is going to be filed and served. It is a civil lawsuit. So I've seen a lot of comments across social like, somebody's going to jail. Not on this, unless they really mess up, like civil contempt of court. And even then, like it's in theory, anything's possible, but this is not a criminal complaint, which when I see people saying, somebody's going to jail, like it's like, Kim, your sister's going to jail. We're not there yet. We are at a civil RICO claim with very large allegations that Tom Girardi was running his law firm as a criminal enterprise. If you want to see that play out, and I did not cover it when it went to trial very much at all, but the R. Kelly trial is a really recent example of a business also alleged, well, he was convicted. A business also charged to be a criminal enterprise. At that point, the criminal enterprise was different than here, but it was his music career and the music the music business, supporting that career being the criminal enterprise. Here it is the law firm that's alleged to be the criminal enterprise. What I really like about this complaint is that it is bringing in all of the other people that we can look at and say, is there direct culpability here? What did you know? Including the accountant and the other lawyers. Yes, again, Erica is the most notable in the public eye in all of this, but but there are those within this law firm that need to be looked at very closely and need to be held as well, more accountable, I think, than Erica Girardi. That does not mean I don't think Erica has, for sure, moral culpability here. I'm still on the fence with the legal culpability. I know, but I understand the theory in this lawsuit. This is my road so far on just this complaint. The theory here is that Erica, being the front woman of the law firm, which is alleged in this lawsuit, the theory as I see it going through this is that Erica continued to make representations in public in the media that kept the enterprise going when those were asking questions. So it was, we're fine, we're this, they apologized, it's good, to allow the enterprise to keep rolling. That's the theory here, versus, which is why she is alleged in the conspiracy to commit the racketeering, not the racketeering acts. The lawyers are claimed to be involved with the racketeering act. And with that, they're the ones who are hands-on and they're the ones who were directly involved. So though we know that Erica benefited, there are allegations here that she was also fronting for the organization. We will see what she knew and we will see how she knew it as this goes forward. And there were definitely people who asked questions on the last video. It's okay to ask questions. We are here to ask questions about these lawsuits. Look, lawsuits are allegations and shade written in the light most favorable to the person that's filing them. We are not here to say, oh, this is perfect, you're totally screwed. We're here to ask questions and look at what's being alleged. So saying, I'm not convinced, I mean, in the comments, a number saying, I'm not convinced that Erica knew, that Erica this, that's the conversation we're here to have about these things. And again, there's a difference between moral culpability and legal culpability. So let us get into me trying to hopefully find my place and put my phone on Do Not Disturb. I have a Do Not Disturb setting for like Fridays and stuff, but I completely forgot to put it on tonight. And I cannot suffer the interruptions because it will absolutely spiral me into ADD madness. So in that, I'll be like, well, who's calling? Why are they calling? I wonder why they're calling. What were they calling about? What could that have been about? Me. So let us go ahead and share screen and get to this so that we can, well, get to everything else. Because I feel like I need to close the loop on the Girardi suit before we move on. So this is part 2. Oh gosh, we're on page 4 of 98. Should I have made a note about where I was when we ended? Yes. Did I? No, but we were right around here. So with being right around here, let's go ahead. I will say, if you are new to the channel and watching, go ahead and subscribe and join the chat. If you know someone that wants to see this video or the topics that we cover, go ahead and share them. So let us get into this. Okay, I make no excuses for Girardi Keith's delay in disbursing your money. So these are, again, the things that are showing that they are keeping it going. So keeping the enterprise going and keeping people from felling the enterprise is part of the allegations here. So we had gotten to a second set, the lulling communications. So the lulling communications are like, it's fine, it's going to be good, it's going to be good, just let us keep going. So that's what that is. And that's part of the allegations that they are saying for wire fraud and obstruction of justice. Boeing wired the entirety of the settlement funds due to Multi Riziki into the Girardi Keys client trust account on June 9th, 2020. The first time I heard about this was in the contempt hearing. So this is a separate client. The first group of clients, the money got wired in March. With this client of Girardi Keys from the Lion Air disaster, the money got wired in June. On September 2nd, okay, look, this should be like a week, maybe two. Like during a pandemic, maybe we give you like 3, but June to September, Multi emailed Griffin and Hatcher to ask about the status of his settlement and when it would be wired to him. Okay. On September 9th, 2020, Griffin responded via email using wire communications and interstate commerce. That is said because of the allegations and the way the allegations are written. So some of the legal language is written in here so you don't just get a motion to dismiss for failure to state a claim like we saw in the Gabby Petito and Brian Laundrie civil suit with the parents. Griffin's email said, quote, Multi, I am doing okay. Thanks for asking. Hope you're staying safe and well. I have sent this to our accounting department and Mr. Girardi. I will let you know as soon as I have an estimate for you. Best, Keith. On that date, Griffin knew that the enterprise had stolen a substantial portion of the settlement. However, because the settlement had come in later than the other 4 Lion Air clients, the enterprise did not yet need to take the step of sending the money to keep him from going to the authorities. Multi emailed Griffin again to check the status of his settlement funds on September 24th, October 1st, and October 20th. So now we're June to October. And this is supposed to happen legit ASAP. Like ASAP. There's no reason it can't. On October 20, 2020, October 2, that says. This is why I pull things up on the screen so you can see them too. On October 2, 2020, Griffin responded via email using email stating, hey, I'm the only one in the office right now. As soon as I hear from Mr. Girardi and the bookkeeper, I will advise best. That's October. So that's what, almost a month later. Emailed Griffin to check the status of his settlement funds October 8th. October 13th, Griffin responded using email saying, I have placed the request for status and will respond to you immediately once I have the information on disbursement, Keith. Emailed again on October 26th. The October 26th response said, I'm sorry that I don't have a firm answer for you yet. I'm sending your request again to our accounting department and Mr. Girardi. The money hit the account in June. On October 29th, it's, I don't have an answer for you. No. Nope. No. Emailed Griffin again on November 6th, this time included a citation to California Bar Rule 4-100, noting that both Griffin had failed to advise him whether they had received the settlement funds and that his request for disbursement of the funds had not yet been processed without explanation. There's rules. I'd like to remind you, there's rules. November 6th, Griffin responded via email using wire communications and interstate and foreign commerce. The email read, hi, Multi, I hope you are well. No, I'm not well. Where's my money? I'd be great if I had my settlement funds. That would be great. That would be great. The only reason this client is involved in this suit is because someone died in an air crash. What we're not going to do is dick them around with the money. Hi, I hope you are well. Unfortunately, I do not have access to the banking and account information. However, I am personally asking our bookkeeper, what did your bookkeeper do last month? Asking our bookkeeper about whether your funds have been received by the firm. I should know by Monday. As far as disbursements, Girardi's the only one who controls the wires and disbursements going out. I have made sure that he is aware of your inquiry. Best. On November 9th, he emailed, hi, Keith. Thanks for your reply. Fuck all the way off on a flying fuck. And where is my money? No, that's not what this says. It says, thank you for your reply. I know that your firm has received the money from Boeing. Oh, how do we know? Did Boeing notify? I wonder how they knew. I'm curious as to how they knew that. But knew that they had the money. I know that your firm has received the money from Boeing, and somehow you are using my money for something else for your own benefit. That's why you guys keep silent all this time. Please convey my message to Mr. Girardi. Fuck all the way off. No, that's not what it says. Damn it. Sorry, I read into that a little bit. For your own benefit. You're using my money for something else for your own benefit. That's why you guys keep silent all this time. Please convey my message to Mr. Girardi. If I haven't received the money by the end of the week, I will notify the State Bar's office about this misconduct. Good for you, Multi. The thing is, this I will report you to the State Bar with what we've read above is not going to rattle anyone, because what the lawsuit alleges in part 1 is that there were 45 lawsuits and the State Bar did dick all about it. So I will just report this misconduct to the State Bar is not really going to rattle many cages, because they're like, yeah, we got them. We're good. We're good. This hurts my heart. Like this, it hurts my heart. And here's why. Soliloquy. Apologies. Sort of. Sorry, not sorry. To get to the point where you are a plaintiff in a catastrophic injury case or a case where you've lost someone, nothing is going to actually fix it. Money is a Band-Aid. But to have to deal with now the minute details of making sure your lawyer is doing what they're supposed to do, on top of the fact that you are still possibly grieving or processing the trauma that you've been through, which also makes it hard to process these kinds of tasks, seems cruel to do to people. Not just like fraudulent and illegal and unethical and immoral, but actually fucking cruel. This is not two multi-billion-dollar businesses pissing about a trademark over something. And yes, intellectual property matters, but it's not the same as people whose lives can actually be changed by this money that they are at the fundamental basis of it entitled to. It's theirs. Not giving them their money is theft. And when your lawyer does it, it's 10 types of illegal. 10 is an exaggerated number. Do not hold me accountable to it. Let us continue. It is 1,000 shades of wrong for me. I'm so annoyed. So he is going to notify the State Bar's office about misconduct. Griffin knew that the accusations were true, this alleges, and says, however, he did not say so. Instead, he responded on November 10th using email saying, I understand, and I have printed your message for Mr. Girardi. I've printed the email out to give to him, so he will see it. Which tracks with the fact that when Erica doxed a federal judge for allegedly having an affair with her husband, the photos were like a screenshot from some ancient fucking flip phone. I have printed your message for Mr. Girardi. I also told you that I would confirm with the accounting department that your funds were received into Girardi Trust, and I have received confirmation that the funds were received. He told you that he knew that. What are you going to do? Lie directly? I can also assure you that I have asked Mr. Girardi to send you the funds to which you are entitled. I can also assure you that I have asked Mr. Girardi to send the funds to which you are entitled. I will update you as soon as I have any further information. Best. However, Griffin didn't stop there. On November 11th, also called Elither, the individual who signed up Multi with Girardi Keese, During this phone call, Griffin was in California. Um, Elether, I'm trying to pronounce that properly, and if I don't, I apologize, was in Virginia. On the call, Griffin asked him to speak to Multi and to convince him to wait till the end of November before taking action to report the Girardi family enterprise to the authorities. Griffin intended for him to do so. But why? But why? But why? If they had the money, here's how that goes when the lawyers get the money. Get the money, give to client. Money, client. Money, lawyer's part of money, client. This is showing that it's like, here's your check, please don't cash it yet, is what this feels like. Here's your check, please don't cash it yet. It's gonna bounce if you don't wait till Monday. From June, July, August, September, October, no, 5 months later. In the evening of November 11th, Elether sent an email to Griffin and Hatcher that read, "Hi, George. I spoke to Multi a little ago, and he agreed to wait till the end of the month to receive his money and not take actions till then. Thank you. We've postponed him. We have stalled him." A few hours later, Griffin, I see this question. Mari, it's a great question. I'm going to get to this at the end of this. So I will come back to that because I'm sure a lot of you are asking. I will come back to that. He agreed to wait till the end of the month. I wouldn't have. But I also understand the stress of being in another country and trying to get your lawyer to act right when you can't even get face to face with them. It's not like you could drive over to their office and knock on the door and be like, "Bitch, you got my money?" No, that's not happening. "Hey, dirty, baby, I got your money. Don't you worry." Said, "Hey." But that song's about an entirely different thing than lawyers taking your money. All right. A few hours later, Griffin forwarded the email to Tom's brother, John Girardi, and Girardi Keith's associate, Chris Umas, with the note, "FYI, Boeing client has agreed to hold off till the end of the month." This is the brother when we went through, correct me if I'm wrong, I believe that this is the brother, based on my memory, that when we went through the statements of fund from the law firm, this brother was getting like 40 K a month out of Girardi Keith and getting paid as like a consultant or something. But this brother, also lawyer, was getting paid from the firm. But wasn't working at the firm. I'm just saying this does not appear to be great for these lawyers. Griffin knew that some of the money had already been stolen and that the enterprise was stealing more of it every day. He was also drawing a paycheck from Girardi Keith, which represented his share of the profits from stealing the funds. Because we saw it earlier that the money was going from the client accounts to the operating account to payroll. Griffin specifically intended his emails to both of them to lull them into a false sense of security and postpone the complaint to authorities, and therefore make the discovery of the enterprise less likely. On December 9th, during an evidentiary hearing on whether he should be held in contempt of court, that hearing was fascinating, Griffin gave the following false testimony in the United States District Court for the Northern District of Illinois. Also a problem, but guess what? The state bar in Illinois can't really take much action against a lawyer not licensed in their jurisdiction other than not let them be admitted pro hoc vice. The court can, the bar can't. The court can, the bar can't. The court has authority over them because they've appeared. In response to questions posed directly to him by Honorable Thomas Durkin, who we stan from the bench. Q. Question. Were any of your answers lulling in the sense that you told Multi, quote, "Don't worry, it's on the way"? Answer, no. I was direct with him. He asked if the money had come in. I told him it did. When he asked when it would be wired, I told him as soon as Girardi approved it. I did not lull him. Griffin knew the testimony was false at the time that he gave it. And that, friends, that warrants me authorizing all of the motions for DEFCON Red. That right there, what we've got not just is lying under oath, like perjury and a problem in the general sense of the word, but being a officer of the court has a duty of candor, not like in the divergent sense, in like the legal sense, but still candor meaning truth. So with that, I have granted your motion for DEFCON Red. Granted. Warning. The intro for DEFCON Red is a little flashy. If flashy things bother you, I understand. The flashy things will end at the end of this music. And we are going to DEFCON Red in 3, 2, 1. We're all the way red. Fred doesn't give a fuck, but we're all the way red. Okay. So with that, I literally can't. Maybe I should have done this second because I am already riled. Erica uses her platform to protect the Girardi family enterprise and the divorce. We went through this. We did not get into the fuckery of these emails and the testimony, but we went through what Erica is alleged to have done based on the subpoenas from the Ruy Gomez family and the fact that she made statements in the media like, we're fine. Like, all of this is dumb. Like, we're, sue and get sued. The thing that was most interesting to me in this section that I will reiterate again because I can't stop thinking about it. Quick sidebar. One of my dearest friends is in kind of a hellacious trial right now based on the facts, and called after trial yesterday and was like, I screamed. And I was like, oh, tell me what happened that prompted you to scream. I want to know why you were screaming at sidebar. And we talked about what the defense had done and why she was screaming and how she had to object in opening. And then audio came in on a murder case that she had tried like a year ago, and that was like horrific and scarring. We talked about that. But then she was like, what are you doing? And I'm like, okay, so I know you're in the middle of this horrific trial with these horrific facts and these very young individuals, and that you had this really disturbing audio come in on this really hellacious domestic violence murder. But can I talk to you about Erica Girardi? And she was like, yes, please. And I'm like, so the attachment on the house was like 2 weeks before the divorce was found. She's like, ooh, interesting. So that was the timing that I was unaware of, because I was unaware of when the attachment went on to the house. The scheme is uncovered. We all started talking about this shit in 2020. On December 2nd, 2020, Edelson PC filed a motion for a rule to show cause in the Lion Air case as to why Girardi Keese should not be held in contempt of court for violating the court's orders regarding approval of the settlement and disbursement of funds. Like, hey, get the money, give it to them. Why didn't you do that? On December 14th, the district court entered a civil contempt order against Tom Girardi and Girardi Keese for violating its order to disbursement settlement funds, and entered a $2 million judgment against Tom, ordered his assets frozen, said, deuces, bitches, we're doing this. I am done. Where's the money? Judge Durkin was having none of this at the beginning. We saw this all go down on Housewives in real time, and revealed to him that the United States Attorney's and referred it to the United States Attorney's Office for criminal investigation. 4 days later, on December 18th, involuntary bankruptcy was initiated. With Judge Durkin, look, I think not error, but I think the error here is that this is in Illinois. This federal judge does not give a fuck about Tom Girardi. This judge was overseeing this massive Boeing litigation and was like, why are you the problem? Like, everyone else has it together. Why can't you get it together? Why can't you just do what you're told? Tom Girardi's reputation is not carrying him in Illinois. Illinois is like, oh, we've seen this. We have seen this. Illinois is not unfamiliar with people doing what they're not supposed to do. I'm not going to say they created it. I'm just saying Illinois, Chicago particularly, is well familiar with people getting up to fuckery. So Judge Durkin was not having it, which I think was the final straw in all of this, was that Girardi saw a big payday but not in his jurisdiction. So when the assets got frozen and everything started to crumble, it was really kind of staggering to all of us to watch it happen so fast. But that's how precarious this house of cards was. But I think Illinois is the key here, and I'm so glad for it. I'm so glad for it. This judge saw through all the bullshit very quickly. And then I'm not done yet. And then looked at all the lawyers and went, and why the fuck didn't any of you tell me about this? Where were all of you? Where were you when this was going down? And that's why the contempt hearings were heard. And the judge asked the lawyers at the contempt hearing, so what can I do to you? How can I sanction you? I've already sanctioned the law firm, and the answer might be that he can't all the way. I've already sanctioned the law firm that is defunct and in bankruptcy. I've sanctioned Tom Girardi, who is in a conservatorship and all of his assets are in bankruptcy. But how do I get to y'all for not telling me? Not happy with this nonsense at all. Let's see. Erica's defense of Tom and bizarre shifting stories about his car accident. No. Not it was snowing in Pasadena. Here we are. And here we are. I love this. Y'all are like, the Midwest tends to be skeptical of California. Well, it worked out well in this case. Erica's defense of Tom and bizarre shifting stories about his car accident. Let's get into what happened in Pasadena. Erica embarked on a campaign to defend Tom after the revelations of the scheme were uncovered. During the filming of Housewives Season 11 reunion episodes, Erica made several statements intended to create uncertainty about whether Tom stole money from his clients, including, I think there is a chance it is not true. I will say, before I keep reading, Emily, keep reading. No. We're feeling sassy tonight. We're going to be sassy. It's going to be like that. Lots of sidebars this evening. I will say, as I sidebarred so hard, I like spit or what? As I sidebar, by the time Erica made statements at the reunion, don't come for me, legal thinking, morality, legality, separate. By the time Erica made statements at the reunion, this had already crumbled. I don't think we can further the empire or the criminal scheme after about December, because that shit is so far out of the racehorse in this case that there's nothing that can be done. That shit is out of the horse. So I don't know if these statements are actually going to further the scheme, because it's over at this point. It has crumbled. It is in bankruptcy. I'm just saying, just keep that in mind. I appreciate the shade in the lawsuit. I just don't know the legal significance of it at this point. So during the reunion, different than things filmed during the season for me, because during the season it was going on contemporaneously, even though it aired later. But during the reunion, the statements made at that time, this was already shit horse out. Okay. I think there's a chance it's not true. Only one side of the story has been told, girl. As to the Gomez family, we know things. We are a long way from finding out what happened here. I don't disagree. We're a long way from finding out all of what happened here. Footnote number 5. Around this time, Erica defended Tom on social media, in one instance tweeting, "Believe me, as many people say he's a villain, there are as many people that reach out to me and tell me what a great job he did for them." So he didn't steal from everybody. Cool. Good for them. Erica made these statements on national television despite knowing that Tom had already admitted to stealing the money in federal court. Fair. And the California State Bar had stripped him of his law license for misappropriating client funds. Well, there's that too. During that episode, Erica also answered a question about whether she was ever suspicious of Tom by saying, Erica was making her own money. I was doing fine. This answer is remarkable because it implies that Erica was spending her own money rather than money given to her through Girardi Keese, which was not true. Incredibly, Erica also used her platform on the season 11 reunion episode to insult the victims of the scheme. True. I don't know if it's legally significant, but we'll go in for the shade. Insult the victims of the scheme. When asked if she felt remorse for the victims, Erica responded by saying, well, they're alleged at this point, so you still have to get to that. That's why that word is thrown around. This monstrosity of fuck shit. I'm just reading it. This monstrosity of fuck shit is going to take a very long time. I don't disagree with that. So that's all I ask for is patience. It will land when these people are properly compensated, if they should be. Not everyone who should be compensated will get compensated here. It's kind of like the Titanic. It is going down and there are not enough lifeboats. And Jack could have totally fit on that door with Rose. I don't know what that was about, but there is no Jack. There is no Rose. There is no redemption arc. There is no door. There are not enough boats. You cannot just jump on the conclusion. Well, with the Rui Gomez family, it's been proven. You cannot just take one article and say, this must be gospel. The LA Times did do a pretty good job. We have a long way to go. Agreed. There is a long way to go in this. Well, the administration of the bankruptcy estate may take a very long time to sort out. The issue of whether Tom stole from his personal injury clients is not an open question. Well, not to everybody. Tom admitted that he did. The accounting records prove that he did. And the state bar has finally recommended he be stripped of his law license, which they still haven't perfected yet at the Supreme Court, but will probably happen. Erica, by contrast, is still trying to denigrate the victims of the scheme by pretending that the court has yet to determine if they are owed money. Yeah. Immediately after the scheme was uncovered, Erica also began parroting a story about Tom's supposed mental decline that his attorneys were advancing. Interesting that they're connecting the two. To that end, Erica began attempting to explain why the decade-long enterprise on tried to explain away the decade-long enterprise on Housewives by blaming Tom's supposed mental decline on a traumatic brain injury that she says Tom suffered in a 2017 car accident. Oh, this is not the snowing one. This is a different one. The son was injured when it snowed in Pasadena, or snowed somewhere when he came down because he flipped his car, and yeah, there's a lot going on. This is a different car accident. Suffered a 2017 car accident. She goes on to tell her housemates, quote, part of true brain trauma is making decisions that you wouldn't normally make. But the 2017 car accident was covered on Housewives Season 8 and was described by Erica much differently than the way she is describing it now. Again, medical records are going to come in handy here. At that time, Erica explained on the show that Tom got into an accident and broke his ankle, adding, it'll be fine, and could have been so much worse. She then repeated, it could have been worse multiple times while shaking her head. If he was showing mental decline then, and she was covering up for it to keep the enterprise going, I think that will be very strong evidence that she was covering for him and propping him up, if you will, to keep the law from going, to keep the money coming, which could go against her, saying, you knew there was decline here. You knew there was stuff here. So maybe, but we will see. We will see what comes out in all of the discovery in this. Erica would go on to confirm this version of the story several times. For example, in January 2018, a few months after the accident, Erica spoke with Michael Rappaport. Is he like the biggest Housewives fan ever or what? I see him everywhere talking about Housewives. Spoke with Michael Rappaport on the I Am Rappaport stereo podcast. When asked about how Tom was doing, Erica replied, perfectly healed. He's great. He's good. Tom is a little superhuman in a way. He healed and he's back at it. So there you go. 2 months later, in March 2018, Erica was interviewed by Jenny McCarthy on her podcast, The Inner Circle. During the interview, Jenny asked about Tom's broken ankle, and Erica nonchalantly replied, he broke his ankle. He's fine. He had 3 pins. He healed up so well, he broke the pins, so he's all good. He broke the pins. I have questions. I have questions. I also have pins in my back, so I have perspective and I have questions. But after the scheme was uncovered, Erica's story about the accident changed dramatically in season 11, episode 10 of Housewives. Here we go, which was filmed on or around December 14th, 2020. Erica tells a new story about Tom's 2017 car accident that Tom drove off the side of a cliff behind his home in Pennsylvania. Pennsylvania, Emily. Where the fuck did that come from? Pasadena. Behind his home in Pasadena, was ejected from his car and rolled down a hill, causing him to break his ankle, shoulder, and clavicle, lose consciousness for 12 hours, and suffer a traumatic brain injury, which again might have been the truth. But if she was covering for it, it's going to hurt her argument that she wasn't covering for this scheme. If this part is the truth. And I wonder if this part is the truth. But we will see when they get to depositions and when they get to discovery and get the medical records, because they'll just get the medical records. The medical records will tell you, or should tell you, what happened. Of course, in these new details about the car, if these new details about the car accident were true, it would have been understandable for Erica to keep them private. Keep reading, Emily. By all accounts, Erica's new story appears to be fabricated. Just weeks after the accident, Tom and Erica filmed a scene in their kitchen for season 8 of episode 9 of Housewives. How much Housewives did those at the Edelson PC have to watch? Who volunteered as tribute? I'm so curious. Who got to watch all of the Housewives for work? I want to know. I had to make my own gig to watch Housewives for work. I want to know who got to do this. Whoever got to do this. Like, this is a dream law student summer internship, getting to watch Housewives for what the fuck Erica said. But there's, Reddit will also help direct you to where. Tom and Erica filmed a scene in the kitchen for season 8, episode 9. Though his shoulder and clavicle were supposedly broken at the time, Tom was not wearing any cast slings or harnesses of any kind and appeared to be moving his arms and shoulders normally. Those things take time to heal, so that would be interesting to see. Further, the Pasadena police have no records of Tom's accident taking place and no evidence whatsoever of the crash. If his car jettisoned down a canyon, it would have to get back out somehow. Erica's bizarre new version of events made her castmates, who were still trying to make sense of the revelations, uncomfortable. Oh, here's Sutton. Everyone take a drink. Sutton made the lawsuit. Sutton is going to call 7 lawyers. Be like, is this okay? Sutton, it's fine. It's just they're talking about what you talked about. Well, welcome. It happens. You talk about the law stuff. Eventually, someone's going to put your name in a lawsuit. You're not responsible. # not legal advice. Sutton said, I just didn't know why we were all of a sudden talking about this accident and why we were talking about this head injury. It was a confusing story. I got a little uncomfortable. I'm not going to lie. And then I think the rest of the girls who knew this story about some car accident were hearing new information from Erica this time around. Regardless of whether her new version of the 2017 accident is true or not, the timing of episode's decision to provide new details when she did while filming on December 14th, 2020 reveals that she is using her platform on Housewives to assist with Tom's defense. Indeed, on the exact same day that Erica's new version of events was filmed for Housewives, and months before it was aired, Tom's lawyers appeared in a hearing in the Lion Air case and raised issues about his mental competency for the very first time in court. When asked what happened to the Lion Air widows and orphans money, Tom's attorney stated Mr. Girardi is 81 years of age and has had issues regarding his mental competence, and requested an opportunity to have a mental evaluation of Tom Girardi prepared. Footnote 6, docket transcript numbers. Let's see. The timing of Erica's decision to reveal the supposed new details of the 2017 car accident, which occurred on the same day that Tom's lawyers raised mental incompetency as a defense for the first time, shows that Erica is colluding with Tom and likely coordinating directly with his lawyers to assist with his defense. It sure is coincidental. In this way, Erica's participation in the scheme is ongoing and continues to this day as she colludes with Tom and uses her celebrity platform to disseminate false facts to the public, including by suggesting that the Ponzi scheme, which has been going on since at least 2010, can be blamed on the supposed TBI that Tom sustained in 2017. Erica leverages the scandal to further her career and stay relevant in the tabloids. We went through that header last time, talking about Erica relishing in the attention. I know she was very active on Twitter last night. With that, there are some that relish in negative attention as much as positive. It all makes me sweaty. I don't like it at all. But we know that. We know that. So to that end, Erica is relishing the attention, even as she is being criticized for her lack of sympathy to the victims of the enterprise, whose money she flaunted on national television as her own. Look, we don't know what Erica knew, but the coincidences of some of these things do not look good. I think, though, a lot of this is after the enterprise crumbled. So some of this might not be legally relevant to whether or not um she was part of the ongoing racketeering, because once it's crumbled, it's a little hard, right? So with that, let's see what else we didn't get to. We got to the got buffoons eating my kitty while I watch cartoons. We talked about the insensitive social media posts. Some of these were made before this all went down. I appreciate the reach here. I don't know how we're going to prove this, Edelson PC, but they liken the orphans and widows earrings, which I think, personal opinion, are more akin to those long Chanel earrings. Do you remember the ones that had part of Chanel spelled on one earring and the other part that all of the housewives wore for like a season? I think it's a play on those Chanel earrings. Edelson PC is saying that this is likening them to the $750,000 diamond earrings that were then taken by the trustee, et cetera, et cetera. I don't know if that's a little bit of a reach for me. I don't know how we prove that. I don't know. Maybe the artist says, yes, they were in reference to the super big ear. I don't know. We'll see. Yes, the posts are insensitive. Yes, the posts are a problem. And then we get to the first cause of action for racketeering against Lyra Griffin, Carmen, and Hatcher. And we went through some of these quickly. I'm going to just touch on the high points, and then we're going to move on at the hour into the other suit we're covering tonight. The Girardi family enterprise is a group of individuals associated in fact for a common shared purpose. And this is laying out the allegations for civil RICO. 1, operating Girardi and Keese in a manner that appears to be a legitimate plaintiff's law firm, but is in fact a vehicle to obtain settlements on behalf of injured clients and steal the settlement funds. 2, funneling those into ventures that increase Tom and Erica's public profiles, permitting Girardi Keese to retain more clients and steal more money. It's like, look, don't you want the fancy lawyer? It's why part of Housewives and part of the reason the women on Housewives show their businesses is because it increases their businesses. And while they have very varying levels of success, didn't Adrienne Maloof have a shoe? Didn't they joke about it being the Maloof hoof? But then you see also successful businesses like, I was going to say Rent-A-Lip, but I didn't mean that. No shade, maybe a little shade. But you see the restaurants for Lisa Vanderpump and the spinoffs. You see some that have legitimate businesses and some that have started businesses while they were housewives because it's a great platform to promote them, and some who have done very well with that. So it doesn't surprise me that these allegations are here, that being on Housewives lifted and elevated the status of the firm beyond the legal community and beyond the Los Angeles community. It's like, people want to go to the doctor they see on TV. It's why the celebrity makeover shows did well for those doctors. It doesn't necessarily matter how good the doctor is, which we saw in the Chalene Johnson lawsuit, those allegations. They had a really large public profile. So I understand that. I guess what I'm saying. The defendants continue to operate the family enterprise together with others. And that's what's interesting to me, is the continue to operate. When does it end? Because the law firm's in bankruptcy. So when is it done? Each has participated in the operation and management of the enterprise with the goal of accomplishing the same common or shared purpose: money. The Lion Air clients were far from the first to be fuel for the scheme. It operated that way for over a decade. These lawsuits go back well beyond that. Embezzling funds from clients who settled cases against Dole. I've been wanting to look into the Dole cases on the long and growing list: TXI, Riverside, Cement, Boeing, Egyptian Air, Pacific Gas, PG&E, Respiridol, Lockheed, and others. And then it gets into some of the other cases On July 19th, 2011, Girardi Keese settled a case on behalf of 139 women who developed breast cancer after taking a hormone replacement therapy, HRT. June 27th, 2012, a large tranche of settlement funds for the HRT claimants was transferred into Girardi Keese's client trust account. Between June 27th, ooh, there's more details with the bank account numbers. These are the type of details that are so um that are so valuable, like actually breaking down where the money came and where the money went. So between June 27th and June 23rd, the Girardi family enterprise misappropriated more than 10.5 million of the money by transferring those funds from the client trust account to themselves without authorization. More than $5.8 million of those transfers occurred even before Girardi Keese told the claimants that their funds had come in. And that's in 2012. Oh boy. Between August 24th and 27th, 2012, Girardi Keese set up interim payments to the claimants in amounts far below what the claimants were owed. Those payments came together with a letter signed by former enterprise member James O'Callahan, now deceased, in which he falsely stated that retired California Supreme Court judge, don't bring in the judges, Justice Edward A. Pinelli had approved the payments. Justice Pinelli testified that he had not approved the payments. He did not, however, what does that say? He did, however, accept a check for $50,000 from Girardi Keese on July 12th, 2012, even though he had been hired through JAMS, which means he should have been paid through JAMS. What? JAMS, by the way, is a mediation and arbitration, a very large and well-known and well-respected mediation and arbitration firm or company that provides retired judges to do mediation and arbitration. But you pay JAMS, and then JAMS pays the level of shook that the tea is buried, like the legal tea, like the deep, deep legal tea is buried down in here. The actual fuck. You guys. Between August 24th and 27th, they sent interim payments saying that the judge had approved the payments, and he testified that he had not approved the payments. This is so bad. He personally accepted a check for $50,000. Wow. Wow. I'm shook. This is why we do first looks. Look, this is why we do first looks. Okay. I'm trying to, like, it hurts my heart. Like, it's professions are supposed to have integrity, and you want to just stuff like this just hurts the integrity of an entire profession and the bench. And for what? Is the money worth it? Because I can't imagine that any amount of money is worth this. By January 23rd, I'm so mad. Like, I'm actually so angry internally. By January 23rd, 2013, Girardi Keese should have been holding 11.8 million in trust for the HRT claimants. Women who were given breast cancer by hormone replacement, holding 11.8 million for them. Between January and May, Girardi Keese sent out about 5.7 million worth of checks. I'm bad at math, but that seems like not $11 million. However, based on the balance available in the account immediately before these checks went out, at least 4.3 million appear to have come from funds misappropriated from the proceeds of other clients' settlements. Of other clients, which again, when we're talking about Ponzi scheme. This is the look, new money comes in to pay the old stuff. New money pays the so when you're look, client gets paid, money comes or case settles, money gets dispersed to lawyer, money goes to client, lawyer takes that part. That's it. This isn't complicated. But when that money is continually chasing, that's where we've got it. It's wild. This is wild to me. Oh my God. This is why we needed a part 2. I'm glad we didn't rush it. The devil's in the details on this one. Wow. The theater doc, I talked about this a little at the beginning. This is a civil complaint, but this was forwarded by Judge Durkin in Illinois for criminal investigation. I'm sure they are looking. Oh, I absolutely got yelled down by other legal commentators for calling it a Ponzi scheme. Seemed like a Ponzi scheme at the time. And I said, seems like it's operating like a Ponzi scheme. Dude, Edelson PC's out here being like, yep, I'm gonna say it like it is, or say it like they perceive it in these allegations in this lawsuit. Not a statement of fact, lawsuit. So let us continue with the wild shit show that is happening here with the settlement funds. So now the clients in this case, the HRT case, are getting paid out from other client money. Oh, God. You know, they said earlier in the law, I'm so mad, I'm getting hot. They said earlier in this suit that there were judges involved, and I made a joke about Erica doxing the federal judge, not the doxing part, because doxing's bullshit, and we don't joke about that. It's fucking weird, and illegal, but about the plastic surgery that she was alleging that this federal judge got from Tom Girardi. And I was like, is that what they meant? Is that what they meant? No, this is what they meant. This is what they meant. Wait, wrong way. This is what they meant. Woo. The contempt motion was denied with prejudice or without prejudice, and the case settled soon thereafter. Wait a second. I missed a paragraph because I got angry. Where's a contempt motion? The contempt motion was denied. What contempt motion? I'm lost. There must have been there's something I'm missing here. Between January and May, Girardi Keys sent out the payments based on the balance available. Those came from other clients. The contempt motion was denied without prejudice. The case settled soon thereafter. Although the motion raised well-documented serious breaches of ethical duties as well as crimes, plaintiff is not aware of any resulting criminal or state bar investigation. Okay, so something just didn't connect, but it sounds like there was an issue in court with this at some point. Nearly 10 years later, the Lion Air clients were victims of the same pattern of activity as the HRT claimants, which we've already gone through up above and alleged in detail up above and alleged with emails up above. Like there are receipts in this. Receipts. They say Griffin personally conducted the affairs of the Girardi family enterprise by committing dozens of predicate acts. Those are the emails and the lulling and the other things they're alleging up above, which include the wire fraud, the mail fraud, the money laundering. Exactly. Those are the predicate acts to get to the RICO. You got to do crimes to have a criminal enterprise. Cayman personally conducted the affairs of the enterprise by committing the predicate acts. That's the accountant. And then they go and list the other defendants as a foreseeable and natural consequence of the enterprise. The victims have suffered. The clients, each of the Lion Air clients have suffered. And now we're finally to claim 2. Conspiracy to commit racketeering, Lyra, Griffin, Cayman, Hatcher, wrongful death claimants, EJ Global, and Erica. All right, let's buckle up. Hopefully there's not too much more tea. The Lion Air clients were deprived money that they would not otherwise have lost, fair, as a direct and proximate result of the defendant's racketeering activities. The Lion Air clients have been injured through the theft of settlement monies and payment of illegitimate attorney's fees, foreseeable natural consequences. So there's not going to be much more detail in this other than what's detailed above, that they were each essential in nature to the scope of the enterprise and intended to participate in and share in profits. Intended to participate and proving to as to Erica intended to participate is going to be the hardest in this. Mishmash, I normally answer questions at the end, but this was such a salient point and it came up in part 1. These Lion Air clients will. So with the Lion Air clients, Edelson PC is going to pay them out of their malpractice and not malpractice insurance, their insurance. And then Edelson PC is suing on behalf of them to recover those funds. These clients are going to get paid through Edelson PC based on what we covered in part 1. So again, back to the analogy earlier of Titanic, I don't think everyone will get paid. So foreseeable natural consequence. Okay. Third cause of action, receipt of stolen property. And we went through these last time. This is against everyone. Griffin, Lyra, Carmen, Hatcher, Wrongful Death Consultants, Erica, and EJ Global. They received monies that were stolen. That's alleged between these dates. Let's see what dates they allege for Erica, and then we will scoot on. When they accepted payment of the American Express balances, Erica and EJ Global did so knowing that the funds used to make those payments had been obtained in a manner constituting theft. Proving that might be difficult. Between March and November 2020, the accountant used the money obtained by the funds held in a manner constituting theft to pay the balances of the American Express cards. What Erica knew about the American Express cards will be really, really relevant. Did she think Tom was paying them out of the personal accounts when she had her husband paying her bills? Did she know they were being paid out of the law firm? And how did she know is the questions I have with that. We will see. Fourth cause of action, aiding and abetting concealment of stolen property. This does not go to Erica. It goes to the lawyers, the accountant, and others that the money was embezzled and that they kept telling the clients, it's fine. Fifth cause of action, money hadn't received against the attorney lending and the owner of attorney lending. Plaintiff incorporates the foregoing allegations as if fully set forth therein. Cal and Girardi Keese entered into a promissory note November 8th, which Cal loaned Girardi Keese a principal amount of $8 million. The promissory note provided that Girardi Keese would execute an irrevocable letter of instruction authorizing payment directly to them from the defendant or its insurers of $3.5 million from the net fees and expenses to Girardi in the Lion Air crashes. That's a lot of really thick language, but talking about the fact that they were directly, and we did this in part 1 too, they were directly promising money back to the insurer or to the lender, not paying it in and then giving it out, but they have to disclose that to the clients, and they didn't disclose that to the clients. So that's where that money hadn't received comes in. Conversion, taking shit that's not yours and making it yours, money. Unlawful and unfair business practices. Do we need to go any deeper into that? All of you are like, instinctually, yes. Instinctually, in my gut, yes. Why is Perkins Coie involved? What did Perkins do? Okay, I'm not saying they did anything. I just want to know how they're involved. On January 31st, 2020, Lyra signed a letter that directed Perkins Coie to pay 50% of the attorney's fees in the Lion Air clients' cases directly to Cal. Oh, Perkins Coie must have represented me. Perkins Coie must have represented Boeing in some part with this. So on January 31st, 2020, Lyra signed a letter directing Perkins Coie to pay 50% of the attorney's fees in the Lion Air clients' cases directly to California Attorney Lending. Lyra knew this arrangement was unlawful at the time he signed the letter. Perkins Coie would have been like, Perkins Coie wired 50% of the attorney's fees due directly to Perkins Coie. Might not have known they didn't have the release from the clients. Lyra and Griffin then stole a substantial portion of the Lion Air client recovery. Cal received monthly bank statements from the Girardi Keese funds. They probably saw the bank statements more than anybody else. Man, Consumers Legal Remedies Act, Business and Professions Code against the lender, Griffin and Lyra. So this is really going after the lawyers, saying you could have prevented all of this and you didn't. deceit against Griffin and Lyra, and that's going to be for the emails and other communications, and that the clients were damaged based on their reliance, and then deceit against Griffin alone for the emails that we would have read up above. Prayer for relief, we went over that in part 1. We're done. We made it. There's a chart and everything. We made it. We made it, y'all. The judge. Like, they named everybody. That and this a lot, I think, is coming up because of the discovery going on in the bankruptcy and the investigation going on in the bankruptcy. Woo! That was an adventure. 13% alcohol by volume's also an adventure. I'm just shocked. Like it was it's always been bad. It's always been bad. Since the beginning of covering this in 2020, it's been bad. And the more and more and more we get into it, the more I'm like, no, 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 like, ugh, no. It- and we will see. There's a lot to come with this. There's a lot to come in the bankruptcy. I mean, we know the house might be in foreclosure. Well, we've seen the reports that the house is in foreclosure. I haven't seen documents in the bankruptcy court, but again, keeping up with the Amber Heard and the Kardashian of it all has been very busy. And then we've got this other lawsuit that we have to talk about. Now we're in 10 minutes in. So, I mean, buckle up for this one, y'all. This is just, you know, I try to go with the we don't talk about Bruno. And then it's like lawsuit after lawsuit after lawsuit. And here we are again to cover this lawsuit. So, with that, we will get to questions at the end. I appreciate all of you questions and super chats at the end. I've got time. No one's living in the house, hockey skate laces. No one's living in the house. No one's living in the house. Easter dress, yes, 13% alcohol by volume. You can see me. You can see it. Like minimal sugar. So I'm going to swipe. We're going to timestamp. We're going to make some chat rules. Just a reminder for anyone who's new here. You can go ahead and pop a 1 in the chat. You can chat if you're a subscriber to the channel. We don't feed the trolls here. We are going to talk about lawsuits. With this, every time, and I've talked about a lot of creators and creator lawsuits and creators talking about suing each other. But every time we talk about this creator, shit just goes off the rails, mostly because of this creator's own actions. That said, we are just going through the lawsuit. We are not here to besmirch, malign, name talk, shit talk. I know there's fuel for that. We don't do that here. So with that, we are just going to be talking about the ins and outs of this particular lawsuit. However, if people want to talk all about that creator, I will just go to members only because the law nerds know the rules. I ask for that because even when people are not our favorite, and trust, we talk about a lot of people here that aren't their favorite. But if we can get through not shit talking James Spears, we can do this, y'all. We can do this. We can do this. And that is always how we've covered the cases here. We do not talk about people, we talk about their lawsuits. So even though this creator makes it very clear that they fucking hate me, I really don't give a shit. We're going to talk about this lawsuit. Lawsuits are allegations and shade. That's what they are. So take it with a lawsuits or allegations and shade. But we are talking about a lawsuit from a TikTok management company against a YouTube creator who we call KJ, but we will just pull up the documents and go through them. Let's just pull up the complaint. We'll go with proof of service first. So that's what we're talking about. I do not care truly what this creator does, says, doesn't say. They talk mad shit about me. We are just talking about their lawsuits. We have so many other people that we need to cover. We're just not. And again, we don't feed people that are internet trolls. So with that, Let's talk about this lawsuit. And the only real reason I'm covering it is because there are allegations here that go into tortious interference with business relations. And when we talked about the Ethan Klein Triller lawsuit, we were talking about tortious interference with contracts and tortious interference with business relationships. And it's a very difficult fit in that case that got yeeted because of an anti slap. It's a different circumstance in this case. So, Penn, we care about the lawsuit. We care about the lawsuit. Look, creator lawsuits are interesting. The reason this lawsuit is interesting is for the reason I just said. Because the tortious interference is a problem, and I'm not saying it's a problem just with this creator. I'm saying it is a problem for lots of creators. There are lots of creators that go after people's sponsors. It's not legal if you directly go after people's sponsors. And we are going to talk about the fact that there are actions for that. So I was going to go over the affidavit of service, but they have a personal service address in here. I don't think it's a business address. I think this creator works out of their home. So I am not going to pull all of that up on screen. I'm just going to read it. But it says, I process service person Bob Yates, state that on Monday, April 4th, 2022 at 4:46 p.m., I personally served the summons and complaint upon Catherine Mansk Paulson, aka Katie Joy, therein named personally at location by handing to and leaving with Todd Paulson's spouse, a person of suitable age and discretion, then and there residing at location. The usual abode of said individual, aka Katie Joy, a true and correct copy thereof, and then they declared it under penalty of perjury. So this has been served. We know it's been served, and we're going to go on and look at the complaint. This was served in Minnesota. Minnesota is fucking weird sometimes. No shade to Minnesotans with your legal system, but you can serve things on someone and give them time to resolve before you have to file them in court. The documents I am pulling up are all court documents. So these are just available court documents that I pulled from the court website, which you will see because they are watermarked by the court and stamped by the court. So let's pull that up now. Where is it? Me, how many lawsuits are you covering right now? Lots. Is it pulled up? Thought it was. Is it actually pulled up? Nope. But here it is. All right. So when you get things from, where is the water stamped bit? Is that just at the end? Maybe I'm looking at the wrong one. Was I just looking at where is the other copy? That's the proof of service. Here's the complaint. Me, confused. All right. Let us pull this up. So once they are filed and publicly available on court, you will see that they are watermarked, not with somebody going into a PDF program and writing their name on it, but with this. Don't worry, we will get to tortious interference later. We will talk about what these causes of action mean. I'm going to go through what is being said in the complaint, and then I'm just going to go through what the law in Minnesota says about them, and then you guys can just do the ones or twos and see what you think, because again, we will do it. So this is the proof of service filed in the district court, state of Minnesota, 4/5/22, 9:36 a.m. So what, yesterday morning? And then normally things take a little time to populate. This is their notice that they get. I, again, love the water stamping. You are being sued. FYI. You are being sued. The plaintiff has started a lawsuit against you. At least they give you a very clear heads up as like what's happening. It's like, FYI, you are being sued. Do not throw these papers away. They are official papers that affect your rights. You must respond to this lawsuit, even though it may not yet be filed within the court. The reason that they do this in Minnesota, I think, from what I can gather, is to not burden the courts if people can settle. It's like, this is what I'm going to do. So if you would like to resolve this, we have some time and you have a year, but it tolls the statute of limitations. The statute of limitations on defamation tends to be very short. In some states, it's a year. In some states, it's 2 years, just depending on the jurisdiction, but it's short. if you serve with this pocket service in Minnesota, it stops the statute of limitations and gives you a year to try to resolve it before it gets officially filed and instigated. And that can save both parties time and money because you don't have to file an answer. You can start with discovery and do those things first. So cases can resolve before they're officially filed and docketed. This has already been filed and docketed. We may or may not find out why. They may or may not have already tried to resolve it and we're met with a big goose egg, or they may just be like, fuck around and find out we're not doing this anymore. So that pocket service is absolutely what it's called in Minnesota, or hip pocket service. Minnesota's a little, they got a little quirkiness to them in their legal system, but it is what it is. So you must reply within 21 days to protect your rights. You must file a written response called an answer. You must respond to each claim. You will lose your case if you do not send a written response. That's called a default judgment, but you have to serve someone to get it. I appreciate that the lawyers sign in purple so you know it's a wet ink signature. I signed everything in different colors so that you knew it was a wet ink signature, and mine. I worked with a lot of judges who did that on search warrants too. They signed them in different colors so that they knew it was theirs. This is the actual criminal complaint. It is numbered differently than in other states because Minnesota. 7M Films Inc., Robert Shin. We're going in with let us have them all tell us who they are and what they are. I'm not going to fill in the background. We are looking at this suit and this complaint, just what is on this paper. Is this going to be sufficient? So that's what we're looking at it. I am not pulling in, look, there's this information and this information. We're just looking at what's filed and seeing if it's sufficient. I know there's backstory. I know there's backstory. I know there's videos on backstory. We're just pulling from what's on this complaint because the complaint has to be sufficient on its own. And a good complaint should give us a good idea of WTF is even happening in this case. So let's make it big and get into it. Parties. Who are the people? Plaintiff 7M Films, hereinafter called 7M, is a California corporation organized and operating under the laws of the state of California. Plaintiff Robert Shin is an individual resident of the state of California. Defendant KJ is an adult resident of Wright County, Minnesota. Defendant without a crystal ball is a limited liability company. Jurisdiction and venue. This court has personal jurisdiction over all defendants pursuant to Minnesota statute. While the plaintiffs can choose where to sue, they have to sue where the defendant is. Instead of suing in another jurisdiction and fighting over jurisdiction, they sued here and we're like, here. There's no jurisdiction issues here. We're just coming to where you at. Factual background. The parties. 7M is a talent management company located in California. Shin is the CEO and sole owner of it. Upon information and belief, KJ is an internet personality and owner of, they went with WCB. Everybody has a different acronym. They went with the YouTube, they went with the acronym WCB. Great. KJ, through WCB, monetizes her social media presence on YouTube, Twitter, Instagram, TikTok, and Facebook. I don't know if all of those are monetized, but okay. Defendant KJ runs and uses various social media usernames and various platforms, including but not limited to, and then they list them. I don't know if all of those are hers or not. Hopefully they will have that information or do have that information. But again, subpoenas should sort most of that out and discovery will sort that out if it is or isn't. The official ones are probably the official ones. Defendant KJ holds herself out as an entertainment blogger. Defendant KJ makes, produces, uploads, quote, drama and or quote, tea videos and internet postings on her various social media accounts. Defendant KJ intentionally publishes false and defamatory material. Again, these are allegations and shade. It's a lawsuit. So they are alleging that KJ intentionally publishes false and defamatory material to denigrate others through sensationalism and fabrication of perceived drama for the sole purpose of enticing followers and viewers to help defendants monetize their various social media accounts. Defendant intentionally engages in quote unquote internet trolling under both her own name and various pseudonyms for the purposes of harassment and causing others consternation, grief, emotional distress, financial ruin, and to otherwise cause damage to their reputations, well-beings, and livelihood. Defendant KJ has a history of intentionally maliciously and recklessly publishing false and or misleading information about various people and entities, including plaintiffs, their clients, and associates. Defendant has at least 2 other lawsuits in this court. I think they mean in this jurisdiction. I don't think these are all in the same. Like when I read court, I think specific courtroom, not courthouse or jurisdiction. I'm guessing they mean jurisdiction, but I haven't looked to see if they're all under the same particular courtroom, but that's just how I read that. So all in this court for her malicious and defamatory statements of others. Yes, because the others settled. Defendant holds herself out as an established YouTube personality and self-proclaimed internet troll with a professed obsession with plaintiffs. Okay, hopefully they will prove that it is professed. Upon information and belief, defendant has openly stated that she will not stop going after plaintiffs until nobody works with them. And that's where we get to the tortious interference that's probably going to come, well, will come later because it's one of the allegations. Upon information and belief, defendant KJ is determined to continue, quote unquote, exposing plaintiffs, their associates, and any business contacts, and any business who contracts with them until they are, quote, ruined. Again, you can expose people if it's true. Upon information and belief, defendant has been sharing private and confidential information about plaintiffs and their associates to her social media pages with the intent of causing harm to plaintiffs. How she would have gotten private and confidential information is a question mark to me. I'll be interested to see what they allege with regard to that. Because generally private and confidential information is private and confidential. Upon information and belief, the improper posts have been published to and are accessible to the general public. Are they still? That's why. Just after covering other lawsuits, are they still? Are they still? Because she would have been served. Let me go back and look at the date when she was served. This is why I brought up the service of process, because once you're served in a civil suit, that obligation to preserve kicks right in there. So April 4th. So I imagine, well, one would hope things haven't been deleted since then related to this suit, or related to these plaintiffs. Upon information and belief, the improper posts have been published and are accessible to the general public, including her posts which contain false and disparaging information about plaintiffs. Social media posts disparaging plaintiffs. Oh, there's a chart. There's a chart. Upon information and belief, defendant KJ has made the following social media posts, which include false statements of fact, which again for defamation is required, malicious and misleading statements, which can be defamation by implication, and defamatory statements about plaintiffs and their associates. A statement of fact is required. Opinion's not it. Like, opinion is not a thing in defamation, but when you talk about it being fact, or it is very vague as to whether or not it's a fact, it can be a problem. Defamation can be hard to prove, but I don't know. Again, it's not really alleged and not discussed. I don't know if whoever Robert Shin is a person of public interest and a person, and if this is a matter of public interest that makes him a limited public figure for the purposes of talking about 7M. And we're seeing that argued in the Kavanaugh-Klein lawsuit as well. So here's posts. All right. So February 27th, 2022. These are recent. I mean, these are pretty recent. So these are pretty recent. Miranda Derrick, I think is a TikToker, a TikToker, was lured into a church 7M. I thought 7M was a business. 7M, this is the post that they're alleging from Instagram. These aren't hyperlinked. I'm not going to Instagram. But this is what they're alleging. Hopefully they've downloaded them because, well, I'm sure that they have because that's how they save them, but you know. Miranda Derrick was lured into a church 7M. 7M is associated with the 7 mountains of influence. 7M believes they need to take over all spheres of the world for Christ to return to the earth. I thought they were a management company. The M in 7M stands for Mountains of Influence, a Pentecostal belief to take over the world, among others. Please see post for specifics. I wonder if that was in the post. Okay, let's real quick just talk about what defamation is. Let's just talk about what defamation is. Just real quick. In Minnesota, defamation exposes a person or group or class to hatred, contempt, ridicule, degradation, or disgrace in society, or injury to business or occupation when somebody makes a statement with knowledge of its false and defamatory character, orally or in writing or by other means. So, videos, social media posts, TikTok, Twitter, whatever. Communicates any false or defamatory matter to a third person. It doesn't have to be published on social. It can be between individuals. And we saw that with Kesha and Lady Gaga. In that defamation case, it was just between the two. Then they can be sentenced for all of the things with regard to the civil liability and what have you. Defenses to defamation, privileged communication. So depending on whether it's privileged, you can talk about it. Court documents fall under privilege. Good faith with respect to the persons participating in matters of public concern. Talking about things that are of public concern, politics, stuff like that. So, was 7M of public concern when these conversations started, and was it good faith? That's one of the questions. Fair and true reporting or fair summary of any judicial, legislative, or other public or official proceedings. So if you're covering something and things have gone off the rails at a Senate hearing and you're like, Senator so-and-so said XYZ about Senator so-and-so, that's you saying that's not defamatory. It's fair and accurate reporting. Misreporting is not covered. Fair and true reporting. Like saying perhaps someone had been accused by an ex-business partner of running a Ponzi scheme. Saying that was an accusation that was brought, if it's an accusation that was brought, is reporting that an accusation was brought. And between the persons having an interest or duty with respect to the subject matter, which I can't even fathom a circumstance where that might apply in this case. So those are your basics of defamation, right? A false, not privileged statement, knowledge of its falsity. If this individual is a public figure, then malice can play into it. Proof of knowledge, and malice tends to be the hard part with public figures. If this was not a matter of public interest before this started, and if this individual is not a public figure but a private individual, then we will not see the malice requirement need to be proven, and you just get knowledge of its falsity, and then you get that exposes the person to contempt, ridicule, et cetera, et cetera. Defamation per se is the cousin, which is, identifying someone as criminal, identifying their actions as criminal, accusing them of committing crimes, or in Minnesota, accusing them of improper or incompetent conduct in their business or trade. And we will talk about that as we go through. And also statements regarding STDs, which we saw in the Cardi B case. So those are the things to keep in mind as we go through the rest of these statements. In your mind, are these things defamatory? Are they not defamatory? They might not all be. There's a lot of statements here. I don't know if saying that somebody was lured into a church is going to count. 7M is using religion to control time, money, and resources of dancers that were vulnerable to abuse due to their economic status, and they are abusing dancers. Abuse tends to lean into the perhaps defamation per se case once we're talking about abuse, if that is not true. And again, they're alleging that all of this is false because otherwise they probably wouldn't be suing for defamation. The dancers managed by 7M Films Management don't pick their own music, sets, clothes, or dances. What? But what though? They don't pick. Does it matter if they don't pick their own music? Does that hurt them in their bit? Does that hurt 7M in their business? I've got questions about that. I've got big questions about whether that's defamatory at all. It's just what? Even if it's not true, I don't know if that's harmful. And they will have to prove that that's harmful. They've got, just like in the Cardi B case, you got to go through each one. And the Cardi B case is absolutely going to be instructive when we talk about, a YouTuber talking about someone, though in that case, a celebrity, and there's no argument that Cardi B's not a public figure. Whether the statements that were made are a matter of public interest is different. And we're seeing that being argued partly in the Johnny Depp and Amber Heard case, but I digress. Let's get back to this. B Dash, is B Dash a TikToker too? Is B Dash the boyfriend of Miranda Derrick? I don't know. Chat, I'm sure you can figure it out. Let us know. B Dash is a victim of the shins he was used to lure Miranda into 7M. Claims Miranda Derrick did not cut ties with her family before she was involved in 7M. 7M has been there's grooming, which is allegations of crime. So 7M has been grooming Miranda Derrick. 7M made Miranda think her family is abusive. The grooming for me might be a problem. Husband, thank you. Husband. Thanks all. 7M is preying on vulnerable dancers, misstates promises made by 7M to its clients. 7M controls its clients' lives, blocks friends and family of its clients from reaching them. Once again, we talked about the elements of defamation and talked about the defamation per se and the defamation per se with regard to somebody's business. I don't know if that's going to fall into someone's saying that they're not adequately running their business, but that's one of the elements in defamation per se, is kind of besmirching someone in the way that they run their business. So, and then we're directly to committing crimes. Okay, well, there you go. For the ones I'm like, there's going to be some that I'm not on. 7M is committing crimes, including human trafficking. I mean, if that's not true, again, assuming they're making their allegations, 7M is committing crimes, including human trafficking, if that's exactly what was said, is going to fall into that defamation per se, accusing people of crimes category. 7M stopped Miranda from being herself. I mean, if we're going to break down each of these statements, just stop after the human trafficking one. Just stop there, because Miranda is not one of the plaintiffs here. So unless what they're saying is that, well, we'll see what they say. Keep reading, Emily. We'll see what they say about that, unless they're trying to say that this is all hurting their business. So we'll see. Robert Shin believes he gets prophecies from God. Again, freedom of religion, but also I don't know if that's opened somebody up to scorn in the defamatory way. 7M cuts all of its clients from speaking with people outside their organization. I mean, maybe when we talk about business. 7M is a cult. 7M is like Jim Jones' cult. Well, okay, that might more liken to crimes. 7M monitors its clients when they are quote unquote outside. 7M psychologically abuses its clients. 7M doesn't allow Miranda Derrick to drive. See post for specific allegations. So once again, when we're talking about the different defamation per se aspects, you don't have to prove damage in the same way, making defamation per se easier to prove, like we saw in the Cardi B case. The Cardi B case leaned heavily into defamation per se with things said by YouTuber Tasha K. And that if things are untrue, this is accusing people of crimes, and accusing people of crimes can be defamation per se. It's not just covered by, it's reported here that this happened. It's reported in this lawsuit that this happened. The way they are typing this, if this is exactly what was said, is saying they are committing crimes. If they are paraphrasing this, then that will matter very much. 7M controls its clients' lives. It's abnormal for management teams to manage their clients' social media accounts. 7M controls everything its clients do. See post. You can't see the post because it's not hyperlinked. If they wanted to see the post, they should have printed them all out and attached them. 7M is destroying their clients' lives. And again, that's talking about how somebody's doing their business. That can, again, if accurately restated, fall under defamation per se. I'm not going to keep repeating if accurately restated. You guys know what I mean. 7M and Robert are predatory. Robertson's church is tricking girls into following them. 7M and Robert Shin are shaming people into joining their church. I don't know what any of that has to do with anything. Miranda and Derrick's marriage is fake and they're lying about it. I mean, unless that goes into the defamation per se stuff. The Shins have been searching for people to prey on. That goes into the business stuff. 7M does not pay its dancers. That goes into the business stuff. Shirley Kim is, quote, always watching 7M clients. I have no idea who that person is because they didn't allege it up above. And that's exactly what the court's going to go on. They did not allege it. 7M clients are all falsely married to their spouses. Okay. I guess this is a continuation of that from 3-2. Every person at 7M has changed their names and has a different alias. 7M's clients cannot do anything without consulting Daniel Joseph, including buying t-shirt and seeing family and friends. Shin tells his clients if they're not submitting to him, they are not submitting to God. If clients miss church, 7M takes away business opportunities. Again, in the defamation per se business. Let's see. 7M's clients have meetings 4 times a week and are forced to work their way into church. If you are pulled out of church, you cannot do jobs and your pay is taken away. Business. Miranda Derrick missed a family funeral because 7M wouldn't pay her if she went. Robert Shin has access to all of his clients' bank accounts and doesn't pay their clients. Their clients don't know how much they are being paid. Shin is telling clients they must submit to him. If they obey, they will be blessed by God. Okay. Dancers' lives are so tightly controlled that they can't do anything without speaking to Daniel first. Daniel Josephs controls the dancers' every move. Again, not a plaintiff here. So if they're going to keep bringing up other individuals that aren't listed as plaintiffs, then name who the parties are to make it a little clear. So, what else? The dancers are worked constantly by the management. Again, this is why we went over the defamation causes of action before. But these are, I mean, these look like all Instagram posts, but this is a lot of posts, like March 1st, 1, 2, 3. I'm guessing these are all separate posts based on the numbering on the side, that these aren't being broken up. It's a lot of posts. It's a lot of posts. Let's see. The dancers are worked constantly by management. Robert Shin is telling his clients Christ wants them to be a certain way. 7M is a cult. Again, cults aren't illegal per se. Religious freedom, we're not going to get into all of that, but holding someone up for ridicule, and if that is playing out on social media, then it will be easy to prove, like, look, these are the responses we're getting on social media after these posts. That either happened or it didn't happen. 7M is controlling their clients' social media. Friends and family are being blocked. We talked about that. Robert Shin is telling his clients, Christ, we talked about that. 7M is a cult, and the cult is that they are preying on Black dancers, exploiting them and convincing them people don't like them for what? Okay, business stuff. Shin's ruined relationship between the Derricks and Miranda Derrick's. Shin ruined the relationship between the Derricks and Miranda Derrick's family. Are these what? That post that doesn't even make sense to me. 7M is a religious cult, tells people not to interact with 7M or their clients because they are a cult. Cult leaders commit crimes, and they're in the defamation per se. 7M is exploiting their clients. See post for specific allegations. Print the posts and put them in the complaint. Just linking them doesn't guarantee they're still going to be there. And these links aren't hyperlinked. Like, if you're going, I mean, just, okay. All of 7M and Robertson's clients are victims, which again, under the defamation per se. Shins are cult leaders. Robert Shin is a narcissistic person. I mean, I don't know if that's going to get you very far. Robert Shin asks his clients to live on his property. Robert Shin told someone that God instructed him to teach young women about sex. Robert Shin has conditioned people not to think and targets young women to induce them into his cult. Katie Joy admits to contacting the LA Clippers to get them to cancel their contract with the 7M and their clients. I wonder what they have to prove that. If they have, because I've talked to creators, and this is aside from this, who have gotten emails from brands saying this person directly contacted us and asked us not to work with you. I just wonder what they have showing that because again, it's one thing calling on social media being like, why is brand so and so still working with creator XYZ, which is different than saying that they've contacted somebody that's a contract and induced that contract to cancel. But I'll keep reading and we will see. We will keep reading. Keep reading. KJ admits to contacting the LA Clippers to get them to cancel their contract with 7M and their clients. Robertson's Shin's church is forcing the Derricks to live in a property owned by them. 7M is a cult engaging in human trafficking. I don't know why they don't just narrow these down to the most salient and relevant parts of it, because with that, you can just go for the stuff that's defamation per se. And I mean, maybe it's keeping the thing in its entirety and it's saying, to be fair, this is the entirety of the post. It's interesting. But also a lot of creators, especially TikTok creators, live in content houses. I don't know if that's what's happening here, but it's not the Robert Shin is a cult leader. Robert Shin does not allow his clients to own their own car. Shin is spying on his clients. 7M is a cult and he SAs women. I mean, if you're going to just stick with some of these are not great. Some of these are not great statements that are not going to get very far. But then some of them are like, well, if that can't be proven to be true, that's a big problem. So I don't understand why not just stick to the strongest allegations, and you don't need to pepper everything in. But also that might be a client choice of, no, this is everything going towards the IIED that's being alleged. Like this is the ongoing harassment. These are all on the same day. Okay. You guys can look at the dates on the side to keep track of how many in the same day, because I think some of they have an intentional infliction of emotional distress claim later. So some of this might be to show that cause of action, not just the defamation. But we'll see what they say. Let's see. So, okay. Accusing someone of crimes. Fact. WOACB located the home she and B- share. The home is also home to, I have no idea who Rihanna is. Shirley Kim is the listing agent for the home. Okay. Posting private information about Robert Shin's address, claiming the property is a cult compound. 7M is forcing clients to live in bad neighborhoods. Robert Shin is stealing money from his clients. All the dancers are grouped into homes within the same area and homes owned by the church and managed by the church. I mean, okay. Robert Shin directed Miranda Derrick to meet with her parents. 7M is a cult. Daniel Joseph of 7M, I still don't know who that is. Like alleged in here. Controls all the clients' decisions. The dancers are living under tight control and not allowed to do anything without permission. KJ has accessed and distributed to the public confidential court documents covered by a protective order. I mean, if they're I just have questions though. Like if they're covered by a protective order, how would anyone get them unless one of the parties distributed them? That's my question on that. If documents are covered by a protective order, you generally can't get to them. So I have questions about that too. And then if somebody distributed them, then does the protective order apply? I've got a lot of questions about that. If somebody's distributed them, just hear me out on the way the brain thinks. If somebody distributed to them, the protective order doesn't apply necessarily to KJ. Like, how does that court order apply to them? If somebody who had the documents under protective order distributed them, I've got questions. I've got questions. I've got questions about that. I'm not, they've got stronger claims, but I have questions about how that all went down. States that this is not about Miranda Derrick and it is about Robert Shin. 7M is a cult using race to distract people from the real issues. What the real issues are. KJ has accessed and distributed to the public confidential court documents covered by a protective order. Are those on the same day? Are those the same thing? Those look like different posts because they have different identifying information. If they would have just attached all the posts, it would have made things much easier. 7M is not only trying to control the dancers, they also want to control the government. All right. 7M dancers exhibit numerous signs that they are being trafficked. Literal crimes. Robert Shin is using the dancers to further his real estate companies. In a sworn deposition, he admitted he used millions of dollars in church donations to further his business for his own fortune, business dealings. Shin propositions women for inappropriate contact. Shin curses people who don't give him money. Like, curse you. Questions. I have questions. Robert Shin demands his clients submit to him. Robert Shin accesses his clients' bank accounts. If it's authorized, then he can. Robert Shin forces his clients to divorce their spouses. That's a strange. Takes money from his church to fund his lifestyle. Does not pay his clients. That's all the business stuff. Won't let people use their own vehicles. Forces people to put their kids in daycare. Accessed and distributed public confidential court documents. That's a third time, but it's just saying that. Like, I have more questions. I have questions. Admitted to setting up a shell company, Mission 2020, in order to form other companies underneath the organization. I mean, shell companies aren't necessarily a problem. He would start a business as DBA and only incorporate it after it became profitable. The businesses generated limited income, but rather were used to funnel donations from the church. Oh, there's the business stuff. The allegations of impropriety were used to funnel donations from the church to him as payroll bonuses or interest. The fact was the money he received via these businesses were donations. But what? Okay, made by somebody else and her trust. He took out loans from the church for these businesses to pay himself via payroll bonuses and interest. He's using the church to shell nonprofit. He's using the church shell nonprofit to defraud people and enrich himself. Well, that goes to the business stuff and the defamation per se. Again, the defamation per se, when I keep saying it goes to the business stuff and defamation per se, it's saying someone is improper or incompetent in the conduct of their business or trade. So when I keep saying some of this stuff goes into the defamation per se, just think to yourself, is this implying or alleging or stating as fact that someone's incompetent or improper in the way they conduct their business? Because I think that's the heart of what most of these are getting to. Claims of accessing protected. I've got a lot of questions about that. But again, we're doing a first look. We're doing a first look. I don't know about the protective order stuff. I've got questions. Claims improper management of church funds, business. Holding dancers captive, crimes. As of today, the court is conducting commercial businesses from the property out of ordinance and zoning. Okay. Sure. Shin and his team are controlling every move these dancers make. They control their money, time. They are forcing them to live in property that they either own or manage. The dancers are being hurt by Robert Shin. The dancers are not paid by brands, don't run their own social media. I mean, I guess that could hurt them too if they are social media influencers and personalities saying that they are not running their own stuff if they're influencers, I guess. They aren't allowed to answer questions and everything must go through whoever Hannah Shin is. They are working long hours. Why is that in a defamation law? Really? They're working long hours is what you included. There's literal accusations of human trafficking, and they are working long hours is what you choose to put in this complaint right now. I have questions. But if they work on social media, they are probably working long hours. Let us just be real. But I guess maybe if the allegations they don't run their own social media, I'm hoping they're just including it for completeness. But also, not everything said in here is defamatory or defamatory per se at all. So it's just not everything in here not every statement is going to fit into one of those categories. They might be trying to show the overall pattern to get to IIED. We'll see what their claim of IIED is. But some of this stuff, I'm just like, there's a lot of posts here. Maybe we don't need all of them, but there's an IIED claim. So, maybe they're choosing to just go with like, look, it's everything. And it's every day, bro. It's like multiples on a day. So maybe that is the pattern that they are trying to show here. The Shins are paying them a percentage after they are paid. I mean, but that's how a lot of management companies work, where the management company or the brand company gets paid, takes a contracted percentage, and then pays the creator. That's like how a lot of those companies work. I don't know why they're putting this in here as disparaging. It's like, but that's how a lot of that works. Then the dancers are required to pay them rent, tithe the church, and donate. Uh, they say Robert allegedly takes away privileges such as going to church, Bible study, spending time with others in the church, work opportunities, and collabs. Well, he lives in large homes and drives a Bentley. He has all of the dancers living in homes grouped together. What, like the like the hype house? Is that what we're talking about? Like the hype like the hype house? Okay. Like team is it like team 10? Someone tell me. I've got questions. So they all live grouped together. Okay. And they pay rent to the church. We asked her, quote, this has no context, but okay. We asked her, quote, are the women at risk of sexual exploitation by Shin? Lydia said, quote, yes, they are at risk of sexual exploitation. And that's where they're going to allege the defamation per se. Robert Shin forces couples to divorce, cuts them off from family, having them live in separate houses divided by sex. Are they married, though? Relationships have been cut off by the dancers because of the coercion. He's taking away privileges and punishes dancers who do not submit, demands full submission. They are not allowed to ask questions because questions are evil. We like questions. We should be asking all of the questions. I have so many questions. Why is this so strange? It's time for I'm disengaged. Y'all, we have pages to go. And we're all for I'm disengaging. It's a lot of allegations. It's a lot of statements. Okay. So I also, them not including the posts for me, you can't see if this is the direct context. So at some point I will go and look on the internet and see if we see these posts. You don't know if these are the direct content. So it's all made as statements, but I don't know if these are the exact statements made. I have questions about that. Or if these are summaries of the posts. And that's where I have questions. Like if they are summaries of the posts, it's different than if they are the exact statements, because there needs to be context, because all of these seem to be making direct assertions of facts. But again, if they're summarizing them, then I have questions about why they're doing it that way, because it makes it A, harder for the court, but it makes it B, harder for all of us if these are summaries and not direct quotes. So with that, take that as a large grain of salt. So let's see. MAC Cosmetics has confirmed to multiple people that they are not partnered with 7M and have no plans to partner with them in the future. I guess if they were in discussions, and we'll see what they allege below, if they were in discussions, that maybe is an issue. So she alleged that after meeting Robert, he isolated her from her husband, who alleged where? Convicted her that he was influenced by demons because her husband didn't support the church, convinced her to divorce her husband, moved her into a home with other women from the church, and took full control of her life. Lydia was a recent immigrant from Korea when she first met Robert and his sister, Catherine. Hi, Fred. How are you? Fred's like, enough. It's done. We're done. I'm awake. It is time to pay attention to me. She was also a trustee of a large fund in Korea, which held millions of dollars. Oh, what does this have to do with anything? She alleged that over several years, Shin and Catherine Yi, who gained access to her bank accounts during this time, she alleged that they were forged signatures and transferred the money out of her trust. I mean, If it's said if it's said where it's alleged and someone else's allegations and they are fairly reported, that's someone else's allegations if they're fairly reported. It just depends again on the nature and structure of some of the posts. Former members allege he forced divorces, arranged marriages, and has had trysts with many women at church. Alleged where? One source alleges that one loyal this is the thing. When we talk about like the Ethan Klein lawsuit, it's like in Variety, the former business partner said this, but like someone alleged something of something is a mess. But if these are summaries, again, if these are summaries, it's my opinion might change. Former members allege he forced divorces, arranged marriages, and has had trysts with many women at church. One source alleges that one loyal woman was used as bait for real estate agents. They allege Robert would send the woman on dates with agents as bait to get listings for their company. Why is some of this paralleling the last suit we were covering? Quote, so please continue to spread this out that people need to stop collabing with 7M or working with them. As long as they are working for Robert, they are being exploited. I have multiple dancers reach out to say the male dancers are actively trying to get young females to join the group. The Shins exploited followers under the guise of religion and to hand over their fortunes. 7M controls its clients' bank accounts. How many are there? Barely works and lives off the work of his cult followers. Her pastor and his wife. This sentence doesn't even make sense. Her pastor and his wife, quote, the woman of God, quote, is also her manager. They dictate her whole schedule. Members must fully obey and submit. Robert and Hannah continue to force Miranda to respond to claims while having her accuse her family of doing what they are seemingly doing to her. Has your kid ever come home from school and told you a story about people that you've never met and they start in the middle and you're just like, and yeah, see, the thing is, with the Tati suit, there was context. Like in these videos, these things were said. In these videos, these things were said. This is literally just a list, which makes it very hard to parse without context. The counts first, and then the chart might have helped, but just the chart makes it difficult, or at least a recitation of what went down and then the chart. But this complaint as written is difficult to parse. I see where they have claims, but difficult to parse again if this is a summary or not a summary. So, but some of the claims, again, if not true, are going to be hard. All right. Let's see. Where was I? Please remember there are dozens of Mirandas that have been victims. Call to stop people from becoming clients of 7M. Oh. Okay. Call to stop people from becoming clients of 7M or working with them. Miranda Derrick has been kidnapped. Well, see, the thing with defamation per se and accusing people of crimes, members are instructed to give 10% tithe. You're allowed to tithe to churches, by the way. 10% gift to thanks to the church, 10% love gift to Robert. Robert encourages that tithes should be more than 10% because the bigger the tithe, the bigger the blessing. Former members say that they were given allowances by Robert and could not deviate from that allowance. The church members stopped having weddings because weddings are wasteful and the money is not for weddings, but the gospel travel is not allowed because it's considered quote unquote selfish and quote doing things for yourself, end quote. You cannot miss any church meetings and there are numerous meetings during the week. Members are taught to submit to Robert, not question. Those who submit can be rewarded with gifts like luxury bags, expensive clothing, jewelry, says the source. Robert stole the money he used to buy his vehicles. Okay. Well, see, look, you get wandering stuff like this when you're like, that one's going to be hard to parse. And then you get things that are a little more concise, like you stole the money. Okay. Well, if that's not true, you have a problem. Pastors using undue influence to not only be the mentor and dictator of their lives of talent, but also managing and producing their careers is a massive conflict of interest. I mean, maybe an opinion. 7M is using a church to run for-profit companies and control their members. I mean, if that's true, again, that's a problem for the church and the IRS. Robert Shin is Jesus God. Robert Shin is waterboarded members of his church. I really hope that's not a direct post. But again, so with defamation per se, accusing people of crimes falls under defamation per se. Okay. Robert Shin refers to his followers as the mighty nation. Why? Oh, keep reading. He is taking scripture from Isaiah 60:22, which says, quote, "The last of his will become 1,000, the smallest the mighty nation. At the right time, I, the Lord, will make it happen." His beliefs of separation of followers from family, isolating them through a belief that they are selected by God, is absolutely dangerous and can lead to drastic events like Waco and Jonestown. Okay, that's why they included it. But okay. Calls on supporters to harass sponsor Forever 21. But what does the post say? Claims Miranda Derrick's paid post about the Do Fasting app is Robert Shin forcing his clients not to eat. Multiple claims about Robert Shin's personal health and relationship with food. Robert Shin forces clients to be thin, claiming he shamed clients for being overweight. Again, reposting Miranda Derrick's paid sponsorship of Do Fasting app and claiming she is the victim of a cult, that 7M clients are under mind control. ATT has cut ties with 7M client following the allegations regarding 7M being a cult. We're almost done. Instagram story stating that Shin targeted his clients and exploits them. No link. Well, hopefully they've got it saved. Instagram story stating that Robert Shin and B-Dash abandoned their children. Instagram story bragging about being the go-to for all information about the cult leader, Robert Shin. No, we're done with that. Are they going to tie it all together? Let's be optimistic. Continued disparagement. On March 10th, 2022, plaintiff sent a cease and desist. Well, that tracks with the defamation suit that you would send that first. Sent a cease and desist letter to defendant instructing her to discontinue any and all claims about 7M, Robert Shin, Miranda Derrick, and any clients, dancers, associates of theirs, in addition to removing all postings she had already made regarding the same. Well, if they asked her to remove post, they're not going to be able to get too mad if she removes post, are they? Defendants did not respond to the cease and desist and are continuing to post false allegations. Plaintiffs and their various clients and associates daily, if not hourly. Plaintiffs reserve the right to amend these pleadings to include any and all posts made after the last of the listed posts and incorporate them herein. Just save them all and send them to the court on a thumb drive. Like in the H3 case. As a direct result of defendants' false and defamatory statements, plaintiff's reputation and standing in the community has been harmed. There's the allegation of harm. Count 1, defamation. We're at the counts, you guys. High five, law nerds. We've made it to the claims. Again, this is a civil lawsuit. Claims are going to be for damages and money. Let's go through the claims. Count 1, defamation. Plaintiffs restate all of the shit above. KJ communicated all the posts outlined in the complaint to hundreds of thousands of people through her various social media accounts. The false statements are categorically false. Which false statements? You've not identified any of them as false. Are you talking? Oh, yes, you did. That's me. That was me. All of the posts outlined above are considered the false statements. I jumped the gun about getting sassy about the wording of this complaint. Apologies, whoever worded this complaint. The false statements are categorically false. KJ knew they were false to be false when she made them, or at the very least acted with reckless disregard for the truth, which is part of defamation. Made the false statements with malice. So they're alleging malice. I don't know if they're going to fight on whether this individual is a public figure or not, or if they're just going to allege malice and be like, look, we've got malice, and this is how we think we have malice, which is going to need to go beyond just saying we have malice. Just making statements isn't going to work. Katie Joy made false statements to further her own financial interests. She monetized web traffic from the sensational and false claims. I mean, when you have a YouTube channel and the statements are made on a YouTube channel, monetization is not hard to prove, but that's again what Kavanaugh argues in the H3 case. Though in that case, the statements were much more concise and much less broad and far-reaching. Um, but in that case, the statements were also misstated in some of the motions, in my opinion. As a direct and proximate result of the conduct of the false statements, plaintiffs have been shunned, avoided, and injured. And now you know why that language is in there, because of the language of the law in Minnesota. By refusing to take down any defamatory posts and continuing to create new content with additional defamatory statements, KJ continues to make false, misleading, and defamatory statements. As a direct and proximate result of defendants' false and defamatory statements, plaintiffs have suffered damages in an amount to be proven at trial, but reasonably believed to exceed $1 million. Count 2, defamation per se. Look, I can see some of the statements, but with the defamation per se, things like, again, they have to be false statements, but things like people are being waterboarded, money is stolen, people are being trafficked, those types of things are allegations of crime. So they're going to fall under that defamation per se. But they also could have narrowly tailored that, but they do have an IAED claim, so I'm trying to be generous, but they could have narrowly tailored that a little bit. They're saying that the false statements were communicated to hundreds of thousands of people. Katie Joy contacted individuals and organizations directly to disparage plaintiffs. How they know that will be interesting. They will have to prove that. If they've been reached out to by companies, like this example I gave above, if they've been reached out to by companies being like, hey, this person contacted us and said this, and we're either going to cancel your contract or not cancel your contract, is in that tortious interference realm, and we'll get to that in a minute. All of the false statements made outlined in Section C of the factual background of this complaint are categorically false. Knew the false statements were false when she made them. The false statements were made with actual malice. False statements were made to further their own interests. The false statements accuse plaintiffs of committing crimes of moral turpitude. These allegations have harmed plaintiff, and that's where you get that defamation per se, different from regular defamation. The false statements have caused and continue to cause reputational harm, mental distress, humiliation, hatred, contempt, and embarrassment. And again, if their social medias show that, they will be able to show that, or should be able to show that. Like, if that's there, right? So if they're getting contempt on social media, that will be seen. So we'll see. As a direct and proximate result, plaintiffs have suffered damages in an amount to be proven at trial, reasonably believed to exceed $1 million. Count 2, tortious interference of contract. We get to talk about torts. Baby, let's talk about you. Tortious interference means it's not criminal. A tort is a civil harm versus a criminal harm. So if any of you followed the day that we wandered down the Petito laundry motion to dismiss, there was a tortious interference claim there that we had never seen before on this channel, and we got to discuss that. We still have a rabbit hole to go down with that one, but tortious interference of contract is exactly what it says. We saw this in other lawsuits. We've seen this in the Triller Ethan Klein lawsuit. It was alleged and failed because they could not prove a contract that was interfered with. You need an actual contract that is interfered with, and the contract needs to be known. If that has happened, then that is why they are alleging this. If that has not happened, then this cause of action will fail. The posts continued to disparage any company who is known to have a contract with the plaintiffs, have continued to use social media to direct their followers on social media to convince third parties who have contracts with plaintiffs to cancel those contracts, which is a problem if, again, as alleged, plaintiffs have contracts with several third parties for various commercial purposes. I mean, that's how social media works when you have sponsors and things. Defendants knew of those contracts between plaintiffs and third parties, and they might use things she said about it because they made some allegations up above about particular sponsors, including, was it Forever 21? So contractual interference is one of those things where you can either prove it or you can't. And that all comes out during discovery, and if that played out on social already, then there it is. Defendants had no justification for procuring a breach of these contracts. a direct and proximate result of the false and defamatory statements. Plaintiff have suffered damages in an amount to be proven at trial, believed to exceed $1 million. Commercial defamation, reinstate the above. Numerous disparaging statements about plaintiff's credibility, business, and services. Again, it's defamation in the business realm, and we've gone through those statements. Hundreds, if not thousands, of posts, including original posts and comments on social media, have been made disparaging plaintiffs and their business as a direct and proximate result of defendants' false statements. Defendants knowingly made false statements and continue to make false statements, which are misleading, unprivileged statements of facts, and intend such statements to injure plaintiffs' financial interests with respect to their trade, profession, and business. Hanging S. Defendants continue to boast about interfering with plaintiffs' contracts with various third parties. See below for one such post. Just put them all in here as an appendix. I'm just saying. Unless put them all in here as an appendix. See below for one such post where defendants boast about getting plaintiffs' contract with the Clippers canceled. Oh. We are always happy for a receipt so we can just evaluate it on the face of the thing because it says what it says or it doesn't. From Instagram, last week I contacted my colleagues at the LA Clippers, okay, to share information about this discovery. What discovery? And ask them to look into it further and possibly separate with the Crump team. I'm assuming that's the dance team, including all of the guys including all of the guys and led by Daniel, where I'm told they always let to them. I know I've been drinking wine, but still, where I'm told they always let to themselves and for the most part disassociated with others while in the arena. Good news, they were canceled for the performance they were supposed to do the same night, as well as indefinitely, and the Clips agreed to launch an investigation into this group further. In the meantime, small victories. Multiple talent agents and managers have told me that the Clippers are cutting ties with 7M. Okay. I've spoken to multiple talent agents and managers, along with industry insiders who have applied pressure to the Clippers management to cut ties with 7M. Well, again, if that's true, and if that's not like braggadocio on social media, if that's true, then discovery will be interesting to see what the Clippers received and why they chose to cut ties, if they had a contract and if they harmed them, because here's a statement saying, I contacted them to cut ties, essentially. Or I've spoken with people who have applied pressure to cut ties. Interesting. Last week, an insider told me the Clippers abruptly canceled Crucified's show for this week. The same thing happened this week. Oh, for the week, the same thing happened this week. We are hearing extremely concerning information coming out about Robert Shin. We have heard that he and his team have been planning to build a quote unquote sanctuary for artists to live, work, and pay them for everything. Is that what the Hype House does? Okay. Okay. Defendants knew that statements were untrue at the time the statements were made or acted with reckless disregard of the truth and knowledge of its falsity. But again, actively contacting the organization to interfere with the contract is where we're at in this, not just commercial defamation, but that's IIED, negligence, deceptive trade practices, intentional interference with prospective advantage, and then the interference with contractual agreements above. So there's two causes of action that really cover that type of behavior. Plaintiffs have suffered direct financial harm as a direct and proximate result. Okay, they have to allege those things. They've alleged them. IIED, we talk about intentional infliction of emotional distress a lot. They reinstate the above. The conduct of defendants as described in the complaint were extreme, outrageous, and beyond the bounds of decency tolerated in a civilized society. And all of the law nerds are like, we recognize this language. Yes, you know why? IIED generally in most states is adopted from the Restatement of Torts, and the Restatement of Torts uses this language that the conduct was extreme, outrageous, and beyond the bounds of decency tolerated in a civilized society. In the Petito Laundry case, when we talk about IIED, my questions come with, is it actually extreme and outrageous if somebody is falling under their constitutionally protected rights? And in a case with defamation, speech is always considered. But again, the First Amendment doesn't protect defamatory speech. So if they are alleging the statements are defamatory, then IIED on defamatory speech can happen. IIED on protected speech can't happen. So, like questioning a politician about policy and they feel harassed by your mean questions is not going to work. It's protected by the First Amendment. Defamation's not protected by the First Amendment. So that's where the things play if the statements are defamatory. So extreme, outrageous, beyond the bounds of decency tolerated in a civilized society is and done with knowledge of the falsity. Members of 7M and their associates have been stalked since defendants began posting the false statements. Again, like in the Ethan Klein H3 case, attributing things people are saying on Reddit to Ethan is not going to fly. Trying to attribute this to KJ might not fly if it's not her doing it. And they're not alleging that it is her doing it. They're just saying that it happened. I'm no doubt that's distressing, but attributing somebody else's behavior, same in the Baldwin kind of incitement defamation case, attributing it to someone if they're not directly calling for it, and even if they are, can be difficult. Members of 7M and their associates have received threats since defendants began posting the false statements. And this kind of plays into why there's emotional distress if the statements, again, are extreme and outrageous and beyond the bounds of a decency tolerated in a civilized society. Extreme and outrageous conduct of defendants included, but not limited to, a series of harassment where defendants published to various public mediums false statements about plaintiffs, including that they are a cult, that they are engaging in sex trafficking, that they are engaging in mind control, that they do not pay their clients pursuant to their contracts, that they force their clients to live in hustle houses, among various other statements outlined in the false statement. See, that recitation up above would have been so helpful. Just that. Defendants have posted numerous videos and statements about plaintiffs daily. Well, you saw the dates on the things above. Those statements were made with knowledge of their falsity or reckless disregard thereto. As approximate result, they have suffered general damages, including emotional distress and mental suffering, which is probably enough for a pleading, but you have to plead that there has been emotional distress. In some states, you have to plead it much more specifically than this. Negligence per se, plaintiffs reinstate and incorporate the above. They knew the false and defamatory character of the statements. They made the statements. Do they have a duty, though? The false statements and to third persons without consent of the plaintiffs. Plaintiffs are within the intended protection of Minnesota Statute 609.765. And plaintiffs suffer that type of harm. Amount of damages of $1 million. Deceptive trade practices. Made the statements. Have disparaged the goods, services, and what have you of plaintiffs by making the statements. They have. Is that going to extend? Maybe, because it's essentially trying to harm a competitor. Intentional interference with prospective advantage it can be very hard to prove. But let's go and see what they say. Plaintiffs have a reasonable expectation of economic advantage from prospective customers, clients, and business, and businesses learning of plaintiffs' business on. Is it me or is it this sentence? Tell me, is it me or is it this sentence? Because I feel like it's this sentence. Plaintiffs had a reasonable expectation of economic advantage from prospective customers, clients, and businesses learning of plaintiffs' business online, it's this sentence, and hiring them or their clients due to online information and their reputation. That sentence is awkward for me. It's a no for me. It's a no. I think what they're trying to say is if these stories are being populated, then it will chill prospective economic advantage, but that can be very difficult to prove. Defendants knew plaintiffs' expectation of economic advantage. Well, they work on social media, so everyone expects future economic advantage. Defendants' post intentionally interfered with plaintiffs' expected economic advantage. Going after sponsors might fit in there, but that might be better with the actual contractual. But Again, with pleadings, not everything might stick. You kind of put all of it in, and we will see. The actual contractual, if someone is directly contracting and saying you need to stop contracting with them, that's different than this. Defendant's false statements are tortious, independent of this claim for interference of prospective economic advantage. And if they prove that, then they can show that this carries on and people won't work with them in the future. But for defendant's false statements, it's reasonably probable that plaintiffs would have had realized economic advantage or benefit. And if they can prove the other one, like other brands have pulled out, and if they can prove that brands that they were talking to have pulled out, maybe, but can be hard to prove. Injunctive relief. Stop it. Please stop it. Oh God, please make it stop. Plaintiffs reinstate and incorporate incorporate by reference all paragraphs previously set forth, will suffer great and irreparable injury if defendant continues to disseminate false and defamatory statements about plaintiffs. I wonder if they're going to try to do an injunction or a temporary restraining order prior to this going forward, which we saw in like the Haley Page case. It's like you have to stop it now, and you enjoin the behavior until the end of the statement. Until the end of the case. Courts are hesitant to broadly enjoin people speaking. So First Amendment speech is something that courts are very reluctant to broadly enjoin. But courts can narrowly enjoin things like, okay, well, some of these allegations of human trafficking and stuff like that, they can tarot an injunction narrowly if they want to, but they're likely not going to say you can't mention them at all, because that is a very broad injunction on speech. So with that, pursuant to the equitable powers of this court, plaintiff requests that the court issue a temporary injunction ordering defendants to make private all posts regarding plaintiffs or their affiliates and only allow plaintiffs in this court to access those posts. Pursuant to the equitable powers of this court, plaintiffs request that the court issue a mandatory and permanent injunction. Well, they're not going to issue a permanent injunction before this is done, but they can do a temporary injunction before this is done. Enjoining defendants from continuing to make false and defamatory statements about plaintiffs at this time, now or in the future. Permanent will be at the result of trial, like we just saw in the Cardi B case, but they can do a temporary injunction limited to the particularly troublesome statement. If you guys haven't watched my coverage of the Cardi B injunction to see how narrowly tailored those types of injunctions are, I covered that yesterday, and you can go look at that, the type of narrowly tailored injunction that we're talking about. It won't be a blanket, you can't talk about this unless it's mutually agreed upon, which I just don't perceive happening. Request for relief. Here's the prayer for relief. We've made it to the prayer for relief, y'all. For a preliminary injunction ordering defendants to make private all postings regarding plaintiffs or their affiliates, only allowing plaintiffs in this court to access. Okay. For a preliminary injunction ordering defendants to discontinue making any posts regarding defendants or their affiliates, unlikely that they're going to do a full you can never talk about us again. There's always going to be bumpers on that, like again in the Cardi B case. For permanent, but swing for the fences. For permanent injunctive relief for defendants to remove all posts regarding plaintiffs and make no more posts about plaintiffs or their associates. For judgment in an amount exceeding $1 million to be proven with specificity at trial, which again, if you want a breakdown of how that goes after trial, the Cardi B Tasha K case, take a look over there because of the breakdown of the different types of damages between the YouTuber and the business, and then the amount of attorney's fees and stuff like that. We covered it really well in that case, how that happens when it goes to when something goes to trial, which things don't go to trial that frequently. For judgment in an amount equal to all sums defendants have made from their posts and traffic to their website as a result of their posts. That, again, can be difficult to prove unless they're talking about YouTube, because this, I think, all listed Instagram posts, unless some of these are lives where they were like badges, but Instagram is not super lucrative. Trying to show what traffic came from Instagram to YouTube is going to be tough. but because they didn't list any YouTube videos, and those tend to be monetized more, but that's just, again, thoughts. Traffic to their website. Again, I don't know if KJ has a website and makes money off of that or not. For such other and further relief is deemed just and equitable, which is going to be damages. So with that, um, they're not going to get an injunction that's going to ban KJ from ever saying their name again. It's not realistic, but a narrowly tailored injunction can happen. And some of these statements, again, if said in this way and if untrue, are going to be a problem. And the contractual interference, the one that they brought up, can be a problem if there's direct contact. Again, that'll be easily proven through emails and discovery, where you get emails and accounts and depositions and statements, and you can get the information from the Clippers directly. Those can be easier to prove. And sometimes to win a lawsuit, it just takes one of the thing. It doesn't mean you're going to get a ton of money, but if you can prove like this contract was harmed here, then maybe. It's some of these statements that are included. I don't know why they're included, but some of the statements I'm like, those are going to be tough. Those are there are some definitely problematic statements in here. Again, if it is an accurate portrayal of what was posted on social, not a summary, and if it was posted in that way and it's not true. So, y'all, we made it. We made it. Look, Ma, we made it. We made it all the way through. It's only been 2.5 hours and we got through this entire lawsuit. So for those of you that are new, you can always put a 1 in the chat and like and subscribe and do the things. But once the complaint is made and filed. And then there will be an answer or litigation, motions to dismiss, jurisdictional motions, those types of motions. So with that, you then go into discovery, which is the process of the sides asking questions under oath of each other, taking depositions, getting emails and stuff turned over. That should be done in a relatively appropriate time frame, though. When you look at civil litigation, like the Amber Heard Johnny Depp case, you see how long some of those because they're still fighting over some of the forensic downloads that are supposed to be done months ago, and they're going to trial legitimately like Monday. So I don't think the court's ruled on that, but if they have, we'll talk about it tomorrow. So that's kind of the process from this. What we saw with the Cardi B Tasha K case is that case took 3 years to go to trial? These things take time. They are long. They are stressful for those involved, and they can be very, very messy. So we will just see what happens. So with that, we should go to questions. I see the super chats. Thank you, everybody. I will go cover those right now. We are just pink from the wine and not from the rage at the previous lawsuit. Let's get to questions. I've got questions. You've got questions. Girl, we've got questions. That was a journey that we all took together. It was so much. It was so much. And some of the things, it's like, why? Why is that in there? Why? Oh, I can see how long ago some of these super chats were made. Matt Bond, yes, yay to Ed Sheeran. What is the lawyer insurance? I have no idea what KJ talks about. I don't follow KJ. But some business insurances, depending on the type of insurance, can cover some types of litigation. A lot of these torts are intentional torts, not accidental. This is not somebody slipping and falling in a business. Defamation and things that are alleged to be done on purpose are intentional torts. Not all insurance covers intentional torts where they pay for your legal fees. Some do. Some pay for your legal fees and your judgments, depending on the type of insurance that you have. So it really just depends. It really just depends. So, new Britney Docs tomorrow for new Britney Docs. There should have been a hearing today. I need to check the probate notes about Lynn's attorney's fees, which should have just fucking been denied. That was crazy. My feelings on Lynn's attorney's fees are a whole lot, but that should have just been denied. I share with my daughter who is finishing law school. She says, Mom, I didn't even sleep 2 hours and now I can watch 2-hour video featuring in grades for professors. Well, there we go. Video works, FT and grade. Well, Yes, mishmash. It might have been me reading that awkwardly. Y'all, tomorrow I'm doing a class at University of Memphis about social media, and I don't know if I'm gonna be able to talk about anything other than, like, defamation suits on social media. I'm gonna have to talk about other stuff when I talk to the amazing students at University of Memphis, but also we're gonna have to talk about some defamation. Also, I'm gonna have to be up early and look cute. So, there's that. Phoenix, thank you very much for the super chat. Um, Jay Edelson was so right about how Erica handles these things. She was on Twitter popping off as this suit became public. So icky and annoying. I mean, her social media response has been interesting. I saw her getting active on Twitter last night, but again, West Coast stuff is past my bedtime. West Coast stuff, it was past my bedtime. Does Erica's book where she shares being out socializing at Tom's dinners admit any guilt or culpability? I have not read her book, so anything on my end would be pure speculation. The allegations are really that she was the one keeping up appearances, but that's not unlike what a lot of wives do. So it can potentially be used to say, but you knew because you were this involved, depending on how involved her book says. I feel like I just have to go through her book. I have a lot of travel coming up. Do I just download the Audible? You guys let me know what you think in the chat. Do I just download the Audible and tell y'all what I think? Because I feel like now I'm at the point where I can't not. Like I feel like I have to. I feel like I just have to. I feel like I have to read the book. Question: can't you get in trouble for ignoring a cease and desist? Kalia, yes. The trouble you get in for ignoring a cease and desist is you get sued. So a cease and desist is a, hey, what the fuck? Please stop. By the way, what you're doing and what you're saying, and this, again, when we talk about the H3 Kavanaugh suit, we've talked about this. Kavanaugh brings it up in a lot of his motions. I sent this. They knew the statements were false because I told them they were false. So the cease and desist is normally used to bolster the claim of, like, the cease and desist went out this day. I said all of these statements are false, so they had knowledge of its falsity and they kept going. Now, the person saying the things, like in Ethan's case, is going to be like, did Variety say this or not? Different than this case. But if you get a cease and desist and ignore it, the result is that they sue you. A cease and desist is a, hey, what you're doing, you shouldn't be doing. I think I have legal rights. I'm going to sue you. And some people will be like, either you're never going to sue me, or fine then, do it, sue me. And then you end up getting sued. So that's the trouble. A cease and desist is a shot across the bow, if you will. I'm not advising anyone ignore a cease and desist. If you get a cease and desist on anything, speak to your lawyer and figure out your own situation. But that's what is happening. So, let's get to some more. So, question: when is the GMAX sentencing now that Juror 50 stuff is settled? Paige, it is June 28th. Hold on, now I got to go to my notes because I got to close the loop. It is June 28th if memory serves, but I'm dyslexic sometimes I just transpose numbers in my head, which is really unhelpful when I'm convinced I need to be somewhere at 10:30, and then it was like, oh no, that's not the right time. I'm like, damn it. So let me just check my notes real quick. But it's coming up in June. The judge made it very explicit in their ruling. And I talk about it in the podcast today. If you've listened to the audio, sentencing set for June 28th at 11 a.m. So the sentencing documents should be coming in soon. Thank you for asking. A huge thank you to the mods. They do rock. We do have chat rules because the law nerd community is a special community on the internet where we have compassionate conversation about laws. And it's hard. There are people we cover that you're like, ick, I don't like what you're doing at all. But just because we don't like what they're doing or don't like them, James Spears, doesn't mean they are legally wrong in the situation that we're in. And that's where the facts versus the fuckery come in, because it's easy to drag people. It's harder to sit back and go, okay, but are you wrong in this circumstance? How does the law affect this fact pattern, pretending you're not you? And we do that a lot, especially in the Britney case. Question: if KJ keeps posting after the service, can it be filed as an addendum when it goes to court? They can file addendums if they believe there's additional defamatory statements. Yes, they can. They can amend the complaint. So thank you. Len and I said, just remember to do the thumbs up. I know, I'm sure you're all just like, we were listening, we were involved. Now is the time to do the thumbs up. Now is the time. Now is the time. Question: will the courts factor in all of these past and present cases involving KJ in such a short period of time, etc.? Does that eventually affect things if it's above average? Well, average is tough. Not necessarily. Sometimes it can play in at trial, depending, because it goes to when you get to the point of knowledge of falsity. When somebody's like, how would I know that this is false? You can try to show a pattern. So could it be presented in front of a jury down the road? Possibly, depending on circumstance. Is it something the court will necessarily consider? Not unless they have to, where the cases are combined. These cases are all different plaintiffs, they're all different things. So, no, for the court, for the judge. Can it come up down the road if anything goes to trial? It can, but it will depend. Can they get a restraining order so she stops talking about them? The company is a public company, so it would be narrow. It would need to be narrowly tailored. You can't just get full stop restraining orders to stop someone from talking about something that they are legally allowed to talk about. You can get protective orders not to contact people. That's much easier. Like, you can't contact us. But it would have to be narrowly tailored to be like these types of statements that aren't protected in some way. So that's a great question, Joy. Thank you. I'm going to get to a few more of our chats. Thanks for the extra ride to finish going through the Girardi case. Cheers. We chic. It was, what I wasn't expecting was judicial bribery being alleged. I wasn't expecting that at all. Insurance adjuster here. Hey, AZ Madison. California requires that we notify claimants when we issue payments to their attorneys. Maybe that's how they knew about Boeing. That is a very helpful point, and that is very possible that the clients were notified directly from the insurance provider, because I imagine it's Boeing's insurance that paid that. So thank you for that. It is a great point of knowledge. This follows perfectly on this question. Why don't they pay directly to the client? Because when there is a settlement, generally the client is not entitled to 100% of the settlement. The client contingent agreements that attorneys like Tom Girardi work on, and not all these agreements are wrong. These agreements, other plaintiffs' lawyers work on contingency, because most of the harmed plaintiffs don't have the money to front these lawsuits that can cost tens of millions of dollars to litigate. So the attorney fronts the fees, normally using a legal lender, depending on the size of the case, like in the Girardi case, when they talk about the legal lenders. And then they do the case, and when the case settles, they get back their costs. Well, do that in the wrong order. They get back their fees. So 100%, whatever their fee is, 33, 40%, whatever. They take their fee. Then they take out their costs. I think it should be the other way around. But, call me a traitor. Call me a traitor to my profession. I think it should be the other way around, costs and fees. That's just me. Fees first, then their hard costs, filing fees, investigators, experts, accident reconstruction. Then the remaining portion goes to the client. That's why it generally goes to the attorney first. But those things should all be known by the time a settlement is in. I don't see a reason why. And again, with Lion Air, some of these plaintiffs were minors, which adds complication to the circumstance that we're not going to rabbit hole on this evening. But attorneys should know the accounting of all the things when the settlement is coming in generally. So couldn't they just wire one portion here and one portion there? It depends on who's paying. The court doesn't always do it that way. Is there room for improvement? Clearly. Caitlin said, catnip tip from my 4 paw nerds to your 2. Thank you. They bounced immediately and are probably hanging out with my kiddo because they got fed. I'm from Illinois. We lock up our governors. Georgiana, Illinois is not new to this game. Illinois is like, we've been around the block, honey. We see it. We are not new here. From Teddy and Fred to George, or from Teddy to Fred and George, catnip tip. Thank you so much. The paw nerds will appreciate it. Thank you for part 2. Looking forward to watching you in Nashville with Adam and Zach. I'm so excited. The Galaxy hair is getting redone. We are getting ready. Look, because Zach and Adam are going to come glam. I saw him redoing his hair. We have to represent. We have to represent. Catnip tip to fun code Fred. Thank you so much. Melody said, much appreciation for the extra ride. As a fellow Middle Tennessean, your Sutton-ish Southern accent gives me life. Thank you. I was trying. to bring the Georgian respect to Sutton and the way that she talks. So I was trying. I am not great with accents. I never mean them in a mocking way. It's always meant with reverence, unless I'm talking about Wells Fargo. And then we're just talking about Wells Fargo. I'm so angry with I'm so angry with the entire file being sealed in the Wendy Williams case. I'm not over it. Thank you for the catnip tip for George. He doesn't appear on screen as much. I mean, it's okay to leave him in a little bit. It seems more like check kiting than Ponzi. Susan, I completely understand that. I think the reason the Ponzi analogy is made is because the new money is funding the old debts to keep people on the back burner or to keep people on the back foot. It's like, no, you're getting paid. No, you're getting paid. But that money's not the money they're supposed to get. It's coming from the old one, the other money. SO to BC survivors like me, donate to local orgs. Thank you, Jess, for the shout out. Allegedly, Angelo, hello. Some, like myself, have seasonal depressions. Others have seasonal loss. Oh, I know, right? LMAO. Anyway, I hope you in the chat have a wonderful time. P.S. Our Real Housewives of Beverly Hills trailer tomorrow. It's tomorrow? I'm going to have thoughts, I'm sure. I'm fascinated to see what goes down. I love Housewives. Laundress, thank you so much. Clemmy said, motion to make KJ's lawyer Graham Martin the laundered nickname of Graham Cracker or Golden Graham. We will see if he earns a nickname. Sometimes it just depends. The lawyers have to bring the sass to get a nickname. Elaine for keeping it classy. Well, thank you. Oh, we're law nerds. We have a code of conduct. Jen Gerard, good to see you. From Yogi for the Paw Nerds. Thank you. Flying Monk Mom Laura, question, what is the difference between public and private citizens when it comes to defamation? Excellent question. I would love to tell you. Should have done this earlier. So in defamation, you have public figures, you have not public figures, and you have limited public figures. So it just depends. Like my neighbor down the street who goes to work for a company every day, isn't much on social media, doesn't have a social media profile, is more likely a private citizen, not a public figure for defamation. But then if there's some huge local scandal, I shouldn't have used my neighbors as an example. They're going to be like, what the fuck, Emily? It's okay. Nobody knows where I live. But then if there's some huge public thing locally that they're involved with, an election, I don't know, or a car crash, something, whatever, they can be a limited public figure for that particular topic. It's like, no, but this one big thing happened. And we see this when things, either good news or bad, goes kind of viral, that people become limited public figures for just that one thing. When you are a public figure, the standard for defamation is harder to prove because you have to prove actual malice. Not just that it's false, not just that someone disregarded it, but they knew of the falsity and completely disregarded the falsity in making the statements with actual malice, going above and beyond. Like Tasha K being like, basically, I knew that was false. I'm not going to stop saying it. So actual malice can be hard to prove. So it's going to depend on circumstance. And being the CEO of a company can put you in that public figure category if the company is a matter of public and going concern. And so it is going to depend. It is something they may choose to argue about. They may not choose to argue about, because some of these statements are made about private life stuff, and some of these statements are made about business stuff. I don't know if they will choose to litigate that, but I always bring it up because there's two parts of that. And they did bring up actual malice in their complaint. Hopefully that was a quick recitation of public figure for the defamation and then limited purpose public figure for defamation. So I'm sure the mods are working hard and overtime. It's an extra ride and we've gone long. And it's like, what's even going long anymore? Because how long are our streams anyway? They're done when they're done. Thank you for the super sticker. Thank you for the super stickers. Thank you. Thank you. Avaloma, why do you make them filing so quickly, not 3 C&Ds or anything? I'm thinking you're saying, what do you make of them? I think that's exactly what you're saying, and I'm reading it badly. What do you make of them filing so quickly, not 3 C&Ds? I wonder if they are thinking that this is damaging and they have to do something to try to stop it. That would be my guess. They're just at their threshold, and it's possible that it shows no sign of slowing, and they're like, we're just not going to wait. We're just going to go. It might be because there's the other lawsuits pending. That's always a consideration. If there are other lawsuits pending, like in the Girardi case, Edelson PC said in their not just in their lawsuit, but in subsequent interviews, that part of filing the lawsuit that alleged that the divorce was a sham was that other lawsuits were popping up, and you have to get in line because, again, you can only get so much. So if you're now behind 3 lawsuits, A, you could be motivated by getting it to stop, and B, you could be motivated by you can't get blood from a stone at the end of the day with a civil lawsuit. Like, there's only so much money that a person has. So those might be some of the considerations here. Um, Super chat from Amy for Florida. It's happening. I can't let it go. Will insurance cover the lawsuit? We talked a little bit about insurance. It really does depend on the type of insurance and intentional torts, and whether they cover lawyers' fees versus covering potential payouts or damages. It really depends on the type of insurance. Insurance can do that, but it depends. Is misopinionated EDB your magic no, I'm me, and I only am on YouTube under my authenticated account. So just me. Autistic Shill said, I don't remember my question, but damn, you're busy. Thank you for explaining the lawsuits. I do well with being busy. Will you do a video on Ezra Miller's legal issues? I have no idea. But I'll look. I can't say yes, I can't say no, but I'll look. I'll always take a look. L Woods, thank you. I'll take it. We did it. Vote for L. Oh dear God, don't forget jurisdiction. Jurisdiction can get you, man. It's right there at the beginning. You got to get it. Tom's scheme was going on before Erica. I don't disagree with you, Dooley Scoot. If the evidence against Erica is that she attended parties, why aren't they asking for what the other wives knew? It seems that in this lawsuit, they're only going back 10 years. I need to look at the statute of limitations on that. You can only pull into activity a certain amount of time back. And off the top of my head, I don't remember, but you've got a statute of limitations of how far back you can dredge stuff up. And we're probably at that threshold. So that's why you can't pattern of behavior so far back if it was known, but it just depends. Question, what are your thoughts on KJ stating she won the Toddy case since it was dismissed? I mean, it depends on the exact statement because it can be splitting hairs. She won her motion to dismiss, but then the case settled instead of being refiled. So it can be splitting hairs, but she won her motion to dismiss. So, I mean, it really, again, it depends on how it's stated, because with the settlement, there was a settlement. So I see it as a settlement with a win on that motion that facilitated the settlement. Wrote about sassy footnotes and how much I love them in my history seminar today. Dawn, that sounds amazing. Looking forward to discussion on music lawsuits. I have questions. I have questions too. And some of those might go up on the podcast only, just because YouTube doesn't always love it when I do music. And I want to use some music for demonstrate. You know what though? With the sponsors, I can do it on a podcast episode, even if YouTube doesn't let me monetize it. So, yep. So, motion, full DEFCON color system, including DEFCON Fred, where your red is the BS and there's a short break for the adult beverage optional and only Fred cam. We definitely need a Fred cam. Question, a dancer told her it was lies in comments. What weight does that hold? Again, without context, it's really, really hard to say. But if you have a bunch of dancers that are going to come forward and say none of this stuff is true, it's going to make it harder. Again, the crux of a defamation suit is are the statements true or false? Did somebody know they were true or false, and did they do damage? We're not even going to argue about the damage here, because that will all get proved. What can you prove that they knew becomes kind of the crux of the thing. So, thank you for covering this and keeping it classy as always. That's what we do here. Look, lawyer skills. For your social media class, you can also talk about the Haley Page. Oh, we're definitely talking about the Haley Page case. Thank you, Pam. It's on my list. We're definitely going to talk about it. Question, could David Lira and the firm's accountant provide evidence regarding Erica's involvement in the family enterprise if she was involved? I mean, I don't think it's going to help them in a civil suit, but can they be asked about it if this goes to depositions and stuff like that? Yes. but I don't think Erica's the big fish in all of this. I really don't. She's definitely the big fish in the media. She's not the one that was working day to day in the firm sending emails to the clients. So I don't think she's the big fish. I think that could go the other way around depending on what she knew. Um, Kafka's cease and desist was pretty thin, right? No dates or times, just wham, mommy, he's picking on me, basically. And that's another thing to consider with cease and desist without seeing them, and one wasn't attached to this lawsuit. You don't know what they say. It could say, stop talking about us. And you're like, you can't ask me to never talk about you again. That's not how that works. So it depends on the cease and desist, truly. And yes, Kafka's was not specifically or narrowly tailored. Let's see. Thank you to the bods. Excuse me. Now my nose is like, meh. Question. Well, the fact that Erica did TED Talks about being really involved in the firm affect her suit at all because now she's claiming otherwise? Again, it's all information that's out there. And in a civil lawsuit, the more information that's out there is the more fodder for a deposition. So if she, and I have not watched her TED Talk in years, but if she's in a TED Talk or if she's making statements that she's really deeply involved, it's all going to come up in deposition under oath and in interrogatories. So yes, it can, because the more that's out there on social media, the more it gives the lawyers, especially lawyers that are thorough, which is what I appreciate about Edelson PC and what I appreciate about Salty and his firm too, is that they're very thorough. They bring complaints that are well researched and they lay it out in a way that's easy to parse. This lawsuit had a lot of stuff laid out. It was not as easy to parse. So when you lay it out and you have thorough attorneys, they're going to go through everything to form their interrogatory questions and their depositions. The more information they have, the more they have to go on and ask narrowly tailored and good questions. 90% of being a great lawyer is knowing how to craft a great question and understanding what question you're trying to get answered. Scattershot does not work. Good questioning does. Why doesn't Boeing pay the clients directly? We talked about that earlier. We got to that one earlier. Now I know how far behind I am in the chat. I'm sorry. I must have missed the GMAX ruling. So the juror thing is settled now. Ali C, the juror thing is settled now. It's in the audio podcast today. The video will be up tomorrow, the next day, whenever I put it up. I think I'm putting it up Friday. I haven't decided. So look, we can pre-plan about 3 days. And it's going up. Is at the same time Elizabeth Holmes is sentenced June 28th. I haven't looked at her sentencing date. It's not going to be till the Sunny Balwani trial is over. I'm not sure how that trial's going. I know there's been some contention between the attorneys. Tom's scheme was going on before. Oh, we got to that one. Now I know where I'm at. Let's see. Question from Missy over on Facebook. Question: if there's any money left in any trust or holding accounts for victims, was that left intact or did the bankruptcy get? Everything's in bankruptcy. Everything in the entire law firm is in bankruptcy. So with the entire law firm being in bankruptcy, everything gets distributed by the bankruptcy court. Mods help keep it civilized. A big old mud mosh pit won't solve anything. I agree. And I don't like chat being a Thunderdome because even though it can be hard to parse, again, emotion and legality, we are capable of doing hard things, even when we've been drinking. Question: what are the chances this gets dismissed? This, I'm assuming, means the 7M. It doesn't seem to be the strongest case. I think it's not as well pled as some suits I've seen. Minnesota doesn't require as much specificity. I think some of the statements in there are strong. They only need to survive on one statement. So for their defamation and defamation per se to survive, especially a motion to dismiss, it would need to be one statement. And there are statements in there making allegations of crime, so those will survive. There's statements in there about the interference with the contract with the Clippers. Those things I think will survive a motion to dismiss. Motions to dismiss are like, you've got no claim, nothing you could say could ever stand, not like assuming everything's true. So when you do a motion to dismiss, you assume everything in the complaint is true. And even if all of that shit's true, you still got nothing. And that's not the case here. You can narrow down and parse down the statements for sure, but it doesn't dismiss the case. We did that. We did that. Let's see. I know I'm behind. Do we have an ETA on Galaxy Hair Friday? So, question from Catherine. What if KJ does have sources who did tell her insight into the cult? Is it still defamation from her repeating what was told to her? It depends on how it's crafted, and it depends on what's said, and it depends on if it's verified. So if somebody tells you a rumor and you repeat a rumor in a way that is fact without couching or without verifying with additional sources or proof, then yes, but it depends on the circumstances, which is why it's hard to tell in some of the way this is structured as to, are these summaries of statements or are these the direct statements? Which is why I appreciated things like the Salty defamation and even the Kavanaugh defamation. I don't agree with their position, but they made it very clear what statements they were alleging to be defamatory in the context of the statement, not a summary of the statement. So it just depends. So, I believe someone yesterday said Erica worked or interned at the firm for a decade. If true, is her defense fully screwed? I mean, it will make it harder. If there is records of her working at the firm, it will make it harder to distance from I knew nothing. It will make it harder to say, I didn't know. Question, if you quote someone else, are you held accountable for it? It depends on the circumstance. A lot of the statements Tasha K made about Cardi B came from an interview that she did. So when you go back and look at the complaints in that case, it started with an interview and then it kept repeating. So if you want to analogize the two, some of those came from interviews and that source was cited directly. But then the repeated statements weren't, this person said this about this and is making these allegations. These people are alleging this. It was this person this and this person that. So circumstance matters. The way things are said matters. Like the specific languaging in a defamation case matters. So question, if she did release confidential documents, what would happen? Again, circumstances matter, but if it's controlled by a protective order of the court, if that protective order doesn't apply to her, the question becomes more, how did those documents get out and then going from there? So again, circumstantially, it depends. And there's not enough circumstance here for it. So that. I'm going to get to a few more and then we are going to go because we're right at 3 hours because apparently that's the length of our stream. Apparently that's the length of our stream now. My father's probate is near done and I realize I have to pay soon. Congratulations with finishing it. A toast to your late father. Probate is hard to go through, but yes, probate's tough. Question, Minnesota can issue punitive damages in defamation cases. Yep. So would multiple lawsuits for similar behavior make her more vulnerable for that? I mean, it depends. If it goes to jury trial, it depends on how a jury sees it. Do they see it as more outrageous? But that can be presented to a jury. So when a civil case is resolved, again, we covered this in the Tasha K case. I'm going to keep referring to the two back and forth because again, YouTuber making statements, they are somewhat analogous. But at the end of a trial, if something goes to trial and doesn't settle, then there's liability or not liability. They apportion the liability to the company, to the person, or jointly and severably to both. It is what it is. Then then the jury decides damages. So when the attorneys argue damages, they can argue that when it comes to punitive damages for reasons why punitive damages should be set to prevent it from happening. Just depends. Question, will you ever do a podcast? I have a podcast. It's called The Emily Show. It's on all of your favorite podcasting apps. And it is regularly in the top 10 internationally for entertainment news. So yes, I have one. No, I don't live in Little Rock. But yes, I have a podcast. Could there be an all purple heart when Emily loves I read that badly, but I need a galaxy colored heart, but I love the purple hearts. Is it true you're going to the Duggar trial? No, I was going to go to the Duggar sentencing. The Duggar sentencing has been moved. If it gets moved again, then maybe, but right now it's moved to when I have another commitment. So No, but I was going to. Let's see. Trailer tomorrow, very excited. That's how far behind I am. Sorry, y'all. I'm very, very far behind. Question: do you think Girardi case will have larger implications for the state bar? Mm-hmm. And I hope the independent investigation makes recommendations. I hope that the LA Times gets the documents they're looking for unsealed, because the LA Times is looking for documents. We're going to get to a few more questions. I said that like 6 times. We're going to get to a few more questions. We're going to go. Questions: can these lawsuits for defamation keep a like a hybrid business? I have no idea. I don't know if there's any upside to this stuff. It's stressful, but also, again, we saw Tasha K being like, look, it's all my name in the media. It's all money. So, isn't church 501c public slap? There is no slap statute in Minnesota. So no, but a church is a 501c3. Does that make somebody a public figure? Not necessarily, but no, there's not a slap statute. KJ says sources are old church members before 7M. How can they verify the trafficking abuse? I don't know. I don't know. And that's a question to ponder for her attorney. So let's see what we're going to do a few more mods again. Thank you. Let's see what else. Octo, it's good to see you. I don't think I've told the Law Nerds that you're going to be in Nashville too. So for all of you coming to Spilling Tea Live, Octo's going to be there too. For all of you that have been on videos where Octo has popped in, just, prepare yourselves. Octo, they're not ready. They're never ready for you. They're not ready for you, ever. So are you streaming live for the Johnny Depp Heard trial? I will stream live for parts of it, for sure. I will. We're going to overlap with some travel stuff, but yes, I will be streaming parts of it. I also know that Legal Bites will be streaming parts of it. I believe Ricada will be streaming parts of it, so you can pick your spice level for legal commentary for the Depp Heard trial. But I will not be streaming it day in, day out, top to bottom, because I have some other commitments. But I will be doing some of it for sure. Let's see. Missy said Nashville or bus, can't wait. Yay! So excited. Octo. I'm like, Kelly B, will you marry me? I'm sorry that I'm already spoken for, Kelly B. Otherwise, I'm always open to marriage proposal. Dr. B and I are celebrating 20 years this summer. It's wild. So, but thank you for the super chat. Question, lip color, please. I have no idea. I have no idea what I did today. I grabbed a lip liner out of my bathroom. It is a Girard Cosmetics lip liner, and it is probably 2 of them. Okay, look, here's the truth. We're just going to tell you that we're all friends here. There's only 3,000 of you here. We're all friends here. Here's the thing. I pulled a lip liner out of my bathroom. I've been too busy. I pulled a lip liner out of my bathroom, and it was maybe not as sharp as it should be. So I started with it, but it was like this one that is not sharp at all because I have not sharpened it. So then I went in with another one to kind of fix it. And I don't remember what I landed on, but I have a number of favorites from Girard Cosmetics. This one is Share, which is one of my favorites. And there's a Red Brick Road that I wear over that. So it depends on that. So that's the truth. I need to leave this out so I can go sharpen it. I started with one and ended up with another. And then I generally throw, depending if I'm just wearing lip liner or not, some kind of a lip gloss over it to stay hydrated and try not to get all of it onto my glass. So let's see. I see you guys talking about Spilling Tea Live. There is also a streaming. So if you guys go to spillingtealive.com, there's a streaming option. They have a show this Thursday in LA with a ton of guests. There will be surprises and fun and probably chaos because Zach makes alcohol with like 13% by volume. So chaos will probably ensue. But if you guys can't make it and want to see it, there is a streaming option and there's a streaming for replay option. So you can absolutely do that. Holy shit, Jennifer Reed coming in with a hard question. You're coming in with the hard questions at the end of the night. What was the most outrageous Outrageous. New thing from this Girardi filing today, in your opinion, the paying for cases was wild to me. The paying the judge $50,000. It's the paying the judge $50,000 for me, but it's also the emails. Like the emails back and forth to someone who's literally like, "I know you have my money. Where is it?" Like, so those two things. Those two things are blowing my mind. Question: will you be covering David Dobrik and Jeff Wittek? If Jeff Wittek sues David Dobrik, I absolutely will be covering it because I think there's a big conversation to have about not just the creator workspace, but safety in the workspace in the entertainment industry. We've been talking about Rust. We this week I was talking about the Oscars slap, which again, workplace. I think regulation is coming to some of the way that people create video. There is so much that needs to happen to create safe sets in TV, television and film and commercials. And then you have somebody being swung around on an excavator, but they're making the same views that you're getting on like a TV show. So I think regulation is a coming for the YouTubes, and I think it is a lot to talk about. Susie, my theory, octopuses are aliens. You and Octo are going to have a great conversation about that. If you guys don't follow Octonation, the world's largest octopus fan club, they are fantastic. Yes, Dr. Riley, the Nashville show will be streamed. Yes, there is streaming. Yes, it is streaming. Spilling Tea Live. How did you get to be such an amazing person? I'm old. Seems like KJ will need an orthodontist to remove the foot she puts. I mean, I don't know if orthodontists remove feet. Maybe podiatrists to remove feet. So it depends. But it's hard. Mr. Beast would never. I mean, it's tough. Congratulations on 36 years in May. Let's see. Question: what kind of backlash and consequences do you expect for the bar and regulators in the Girardi case? I have not even thought it all the way through because the whole thing still boggles my mind, but there has to be some changes to allow this to not happen again. The hard thing with the state bar is that most of the people that were involved are gone. A lot of these things were brushed aside years ago. Again, I'm hoping that the LA Times stays on it, and I can't wait to see. So it's time to say goodnight. It's 3 hours and 10 minutes. The mod squad has been fantastic, and I appreciate you. Question: what nerdy gamer areas of your life have you been neglecting in order to provide us all this great content? This is the kindest question I've ever been asked in my life. I think I've missed all of cherry blossom season in Animal Crossing. And I also didn't catch all of my dittos on Ditto Day. So now I'm one ditto shy of finishing my tasks in Pokemon Go. But those are the first things to go because life and family and kids. Also working out, like eating dinner. My dinner is still in the fridge, which makes having 2 glasses of wine extremely smart on my part. But I'm going to go eat some dinner. I'm going to take a bath. I'm going to hydrate and mind my business. And then we're going to go. It has been. And then tomorrow I'm going to talk to the young and impressionable minds at the University of Memphis about social media. Oh, you guys are like cherry blossoms are still on. Good. I'm going to go do that because I don't need any more eggs. I love the cherry blossoms so much. Look, living in Middle Tennessee, one of the things I was not expecting, and I should have, because when the times I had visited in the spring, we went to Centennial Park, and the cherry blossoms are amazing and reminded me of being in DC in the times I've been in DC with the cherry blossoms blooming. I love them so much. I have cherry blossoms on this wrist. Yay. Did you raise the proper hand on the internet? I did. Cherry blossoms on this wrist. I love them. Middle Tennessee is just chocked full of cherry blossom trees, and I was not expecting it. I love it. I love it so, so much. Thank you everyone for being here. Thank you for being a Law Nerds. Thank you for the mods for being like, extra ride, we down. Tomorrow night, we will be back. There are new Britney documents. There should be new Britney rulings. There was other stuff we're going to talk about tomorrow night. I don't know off the top of my head what it is. I've got it on a list somewhere. There are things happening. There are more things happening in the law. We're going to check back in with the fire that is happening in the USC water polo coach case. I am absolutely going to check on what's going on with the Sunny Balwani case. I am behind on watching all of my Housewives, so I have no idea what's happening, but I will absolutely have thoughts about the trailer from Beverly Hills, I am sure. So tomorrow night, we are doing Friday Night Live on a Thursday. Yes, because I need Friday night off. I have hair on Friday. I need Friday night off. I need Monday off to rest for live event, because though I can be quite extroverted, I also need time to be ready for a live event. Next week, I have a live event. I have a talk. My friends are coming into town, lots of them, and we're going to get to do things. So Friday Night Live is getting bumped. But I've finished Bridgerton. Oh, Foxy Project. We have priorities. I have finished Bridgerton. I loved this season of Bridgerton. I loved the storyline. The actress who plays Kate is so freaking stunning. I loved the strong female protagonist. I loved this season. I loved so much of this. You guys know how much I love Shonda Rhimes. I mean, one day Shonda and I will be friends. But she's the friend in my head. I listen to her book every year. It just, we embrace the year of yes, which is going to make travel very complicated because life and family. So we are going to stay hydrated. We're going to mind the lawsuits. I will see you back here tomorrow. If you guys they're distracting me with great questions, JC. I love it. So I will talk to all of you soon, literally tomorrow. And if you're watching in the replay, crew, love you so much. We've gotten from wine back to water. I will talk to you all in the next one. Do the YouTubey things. And for quick updates, I'm on the social medias at the Emily D. Baker everywhere, and I will text crew. There's other things. They're all like linked in my bio on Instagram. It's fine. Bye. Connect with me everywhere. I'm at the Emily D. Baker. If you guys want to join the text, just text Emily.com. If you want to join the channel, lawnerdsunite.com. Happy to have you. Support what we do here on the YouTube.